Supplementary list, fresh admission, item number 1.
Yeah, please
Millard,
note.
Millard, in this case, Millard, in
I
this
am the respondent number 1 in both the matters.
Both matters?
item number 1, WPC 3668 of 2023.
Sorry, madam.
Millard, in this case, after filing of my last affidavit dated 21st February 2023, and as per the order of the Honorable Court, after serving of its copy to the learned counsel appearing for the state, the collector has passed an interim order to stay the construction work on the spot. But actually, the construction work is going on, Millard. In this connection, I am filed another affidavit that is on 23rd March 2023, Millard. And in this affidavit, I have also filed one document. Last settlement, the entire land belongs to Lord Jagannath. Let's see, may kindly have a glance on page 5 of my affidavit dated 23 March 2023. Millard, that is Amruta Manoi Sri Jagannath Mahaprabhu. It has been mentioned on page 5.
May I submit one thing? My Lord, as per the direction of this Honorable Court, the collector accepted the representation. He filed a repetition stating that I have filed the application for interim stay. Collector is not passing any order, and I instructed him to pass interim order. And the interim order was passed on 24th February. Now the representation is to be disposed of in pursuance of the order passed in WPC 2943. Let him wait.
Collector's orders, he is not able to get the collector's orders. Why is that? He says he's applied for the 6th January order, the 24th February order.
He admits that stay order has been granted.
But he's not got copies.
That your lordship, I will ask him the copy. Let him file an application.
He says he has already filed
under RTI Act.
No, para 5. Have you served this affidavit on him? The additional affidavit?
Yes, I have received.
Come to para 5.
No, he has asked for certified copy. I will ensure that he will get. But my responsible submission is that he has already passed the interim order. Now the collector is to pass the final order on the representation.
So he says despite interim order, construction is still going on.
Yes. That is, if that is there, then the notice may be issued to the video.
I ask the collector to remain physically online, present online.
No, collector has passed the order. Now
Somebody has to implement it, sir. Passing is one part of the.
Then video is maybe asked to remain present, because video is, according to his affidavit, video is not obeying the order of the collector. So video may be asked to remain present. Both. Why? Both. According
online presentation.
No, my respectful submission is that Millard, he is saying that collector has already passed the order. Video is not complying the order.
There are two grievances made by the counsel to the petitioner. One is that he's although interim orders have been passed by the collector Baleshwar on 24th February 2023. Right at the beginning, you say an additional affidavit has been filed with the petitioner in which he makes two grievances. So one is that despite the collector having passed an interim order on 24th February 2023, directing the video Bahanga to stop construction, he is unable to obtain a certified copy of the said order despite applying for it. Stop. The second grievance is that construction work on the disputed land has not yet stopped despite the above order. Paragraph. Mr. D.K. Mantri on AGS states that he will ensure that the collector's orders dated 6th January, 24th February and 17th March are made available to the petitioner. Certified copies of the orders are made available to the petitioner positively by 5th April 2023. It is reiterated that if paragraph, if the collector has indeed
10th April, because I have to intimate then.
No. Certified copy, can't delay it so much, sir. He has already made an application 30th January, 27th February, 20th March.
Yes.
3 applications have already been made.
It's so.
You say if it will be the responsibility of the collector, Baleshwar, to ensure that the BDO Banaga obeys his interim order. Full stop. List on 10th April. Both the BDO Banaga as well as the collector Baleshwar will remain present in virtual mode on the next date.
Item number 2.
May I please the Lords? My Lord, this is a PIL in which the intended beneficiaries are students who have taken admission under Section 12(1)(c) of the RT Act in private schools of Odisha. Lord, in the previous occasion, my Lordship had asked me to check if there was any other similar writ filed on this particular issue. My Lord,
No, there's a reference made to a High Court order.
My Lordship, the High Court order which it is referring to, that is for fee waivers, and because the representation covers 5 different points. So the High Court order refers to a fee waiver and not on the right to education extension.
I see. All right.
My Lordship, the main concern here is that every year around 8,000 or more than 8,000 students take admission using the benefit of this 12(1)(c) provision in different private schools. The number of seats is much more, but till now, since the awareness is less, around 8 to 10,000 students are taking admission. And these admissions have taken place from 2010, when the state of Orissa has notified the rules for the right to education under the Right to Education Act. My Lord, at present, after class 8, these students who are studying in these private schools have to pay the full school fees. Till class 8, the state government provides them reimbursement. The reimbursement amount is also stated, which is around 25,000 in schools providing entitlements and 22,000 per child in schools without entitlements. My Lordship, in this case, so any student after class 8, and the condition to take admission is that they should be from disadvantaged and weaker economical sections. Lordship, how would these students after class 8 pursue education in the same school by paying the school fees when they are not economically and financially stable, when the families? Presently, this is a central act, my Lordship, and I agree that any kind of legislation, if I ask for any kind of legislation, it would involve a central act or a new central act coming in. But presently, the state government of Orissa has also shown a huge inclination towards the education sector of children. And almost 75% of our budget goes towards the education sector. Lordship, in this case, if the state of Orissa, till class 8, they are providing reimbursement for these students, my humble submission in this PIL is that beyond class 8, those students who are interested or willing to pursue education, they may still be considered and covered under the same reimbursement scheme. And I've also referred to, my Lord, an instance from the government of
This is your representation for that, is it?
My Lordship, I have made
You put so many things in the representation, that's why it was
it was a little
all over
confusing.
the place.
Lordship, the state of Chhattisgarh has
So what is that to show you've delivered this representation?
my Lordship,
Just see this annexure 7 series. That's your representation, right?
Lord, annexure 7 series.
So
Annexure
how do we
6.
know that this was delivered to the addressees? Do you have any proof of having delivered these representations?
Having delivered, my Lord,
How did you send it? You sent it by speed post, or what did you do?
My Lordship, generally the petitioner is a part of a lot of discussions with the government, and they have always submitted representations by hand. And in case that
not by hand, nobody goes, because let's look at this 11th January. You've addressed it to 3 people, right?
my Lordship,
Chief Secretary, they don't sit in the same place. So where's the question of just giving it by hand?
Lord, in that case, I would have to ask for a copy of the receipt copy.
Yes, sir. Would you know if these representations have been received? You're appearing for the school and mass education.
My lord.
Ah,
My lord, he may file a press representation. my lord.
all right. Since it is not clear if the representations at Annexure 7 series have in fact been delivered to the addressees, the court permits the petitioner to file a separate representation to the authorities concerned, specific to the issue of grant of reimbursement benefit to students belonging to the economically weaker sections and pursuing studies in classes 9 to 12.
My lord.
If such representation is made not later than 24th April 2023, then the Commissioner cum Secretary, Department of School and Mass Education will, after hearing the representative, one or two representatives maximum of the petitioner federation, communicate to the federation the reasoned order thereon, not later than 1st June 2023. The date of hearing of the representatives of the petitioner should be intimated to them at least 1 week in advance. The court clarifies it has not expressed any view in the matter. If not satisfied with the response of the state government, it will be open to the petitioners to seek appropriate remedies in accordance with law.
Obliged, ma'am.
Item number 3.
May I please, Your Lordship? Case relates to illegal construction over public road. Your Lordship just have a glance to Annexure 6, paragraph 3, page 18, which Your Lordship's permission I am placing. Annexure 6, page 18, paragraph 3. As per the report of the RI, it is revealed that Sri Anadir Aipitam OP has constructed a building over government plot which needs to be demarcated. But the said OP is not cooperating and making hindrance for demarcation, for which it is difficult
So
to
this
locate.
Annexure 8,
My lord, Annexure 8 is the representation to the collector.
where is the proof of
My
delivery?
lord, that is Annexure 4, Your Lordship. That is the representation has been given to the collector, and collector has intimated this is the registration number. Whenever you intimate, you refer to this registration number. That is Annexure 4. Of course, it is in Orissa. They have, the collector office has intimated to the.
The date of your representation is 23/2.
My lord,
But
that
this,
is,
this Annexure
it is
4 is 21.
my lord, 21.
20th
That is
January.
earlier, Your Lordship, earlier 21 January, that is 21st January, 20th January 2023, that was given.
All right.
And they have
Petitioners,
intimated
all right.
me that
The
this is the
petitioners-
registration number.
All right.
Whenever,
1 minute, sir.
My lord.
Petitioner's representation. Bracket Annexure 4.
my lord, Annexure 4, Your Lordship, at page 16.
4 is not the representation, it is the acknowledgement of acceptance of a representation.
Which representation is acknowledged in
Eight.
Annexure 4?
That is, Your Lordship.
My lord,
Annexure,
he has filed a representation Annexure 8, page
8.
20, but that does
is
not relate
acknowledged
to,
in Annexure 4.
there is no
Which is the
proof of
representation
delivery.
acknowledged in Annexure 4?
Yes,
Annexure
that is
4, Your
not-
Lordship, I have not attached that representation.
Then-
That is, of course, in Orissa. For that reason, lengthy representation, Your
No,
Lordship.
but which one should they consider?
My lord, Your Lordship may give me liberty to file another press representation, and they would
All
consider
right.
my case.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh representation, and after following up on such representation, seek appropriate remedies in accordance with law. Disposed of his withdrawal with liberty.
Your Lordship, time limit may be given because construction over a public road, for that is
Asked
the
you
reason.
file the
You have to
representation.
file it first. All
My
right.
Item number 4.
The memo is taken on record. No instructions dismissed.
Item number 5.
None appears dismissed.
My lord, I'm appearing for item number 5, my lord. If I may please your lordships. My lord, in this case, the applicant initially got an appointment in the year 1990, my lord. After that, I was terminated in the year 2003, followed by the principal intimated the same letter of termination in the year 2004. And they have alleged that I have asked for the resignation. Be that as it may, I appeared before the Director of Higher Education, and the Director of Higher Education rejected my application. I then again went to the tribunal. The tribunal said that it cannot be appealed before the tribunal challenging the director's order. In 2005, my lord, I filed a writ petition, which was converted to an FAO, my lord, where I got the liberty of filing the writ petition before this honorable court, my lord. That is in annexure 8, my lord, page 32. This honorable court has granted us liberty to file the same liberty to appear in the form of a writ petition, my lord. The same writ petition we had filed in the year 2010, my lord. But after that, in 2010, it was stated as infructuous by honorable single judge. That's why the writ appeal, my lord.
No, but in 2010 itself, she was 49 years. Now she's more than 60, sir.
I was 58 in the year 2019 when we filed the writ appeal, my lord. I'm just challenging the termination. I was never heard. That's my whole submission before lordship. All this time I was just taking liberty to file where to file and where not to file, my lord. And this time I'm supposed to be heard, my lord. I was never heard. Not even 2010, not even in 2019. Before I challenged.
Is this a pensionable post?
In 2004, it became a granted college, my lord. Before that, it was a governed body. When I was appointed, it was the only post for the post of ODI, my lord. Let that be heard in merit, my lord. The matter has become infructuous before even hearing to me or any of my submissions, my lord. All the time, starting from the impugned order of 2003 till date, my lord. All of this time.
No, but there's also a problem with limitation, sir. The termination order was 79/2004.
Obliged, my lord, but that's what I'm trying. That's what I'm trying to.
Presented the appeal only on 7/2/2005.
That's what I'm trying to convince your lordship, that I'm only going through the stance of maintainability and limitations all this time.
Naturally, you have to overcome that, sir. You have to overcome that.
If I will, your lordship may see, my lord, in the date chart, my lord, I have only given all this time, my lord, starting from 2003, 6/8/2003, my lord.
Where's your date chart?
Page 3, my lord. Page 3 of the writ petition, writ application. My lord, if I may please your lordship, 6/8/2003, my lord, I was terminated. The same was communicated me through the principal in 22/2004. On 3/3/2004, against the order of dismissal, the appellant approached the learned director, Higher Education, Odisha, my lord. On 17/9/2004, the director observed that the governing body of the said college accepted the resignation of the appellant on 6/12/2003.
No, but something there which you're missing out, sir. Apparently, you resigned on 6/12.
That's the alleged thing they have given, my lord. It is, your lordship also may have a glance simultaneously at annexure 8, my lord, on Honorable Justice M.M. Das' order. They have said that they are alleged. I have alleged that I have taken the stance. I have never given a resignation, my lord. They have alleged. That's the word written.
Anyway, either way, then if you say they have not resigned, then if you were removed on 6th August itself.
They are alleging that I have resigned in December, my lord, 2003.
Yes.
Before that, there was the termination. Yes. And that same termination order was communicated to me in the year 2004, my lord.
Right.
So all this time, your lordship, I've been asking only one thing, to be heard in merit, my lord. I've been just running here and there just for the limitations part and so far as the maintainability part, my lord.
Yes. This is an aided college, is it?
My lord. That's also came into effect after my termination in 2004, my lord. 1/1/2004.
Who's for the opposite parties?
At the time of such termination, that was an unaided college, a private college. So in 2000,
when did it become a government college?
Thereafter, it has been aided, man.
No, when?
After 94. After 2004.
So before her dismissal or after her dismissal?
After his termination.
Sorry?
After his termination, that has become aided, my lord.
It became an aided after the termination.
After her termination, but it was communicated by the principal after it became aided college, my lord.
But either way, sir, since the termination took place before it was an aided college, then it's a private college. How is it maintainable? How can a subsequent management be answering the actions of an earlier private management?
I bow down before Lordship, but the same was given. I mean, it was intimated me to the principal of the
Whatever,
same.
sir. Whenever it was intimated, you should have filed a suit.
And he was also 49 years in the year 2010.
She was.
Now he most probably.
No, that is true. He only says that never been heard. You say the grievance of the present appellant is that she has not been till date been able to get redressal for her grievance against an order dated 23rd July 2003, passed by the management of the Gopabandhu Women's College, Atagad, Cuttack. According to her, she was informed of the termination order only on 20th February 2004. By which time the college in question became an aided college.
With effect from 1/1/2004.
Bracket, with effect from 1/1/2004. Bracket. The fact remains that at the time of the termination of her services, the college in question was only a private college. And therefore, the subsequent event would not affect subsequent event of the government aiding the said of the said college being an aided college would not change the fact that the remedy against the termination order would have to be by way of a this education tribunal is only for aided colleges, is it? By way of a civil suit.
Oh, my lord, there was a principle, my lord. There was a principle, 83 principle, my lord. On aided colleges, my lord, they have to approach, they have to file appeal before the diet.
No.
That is there.
This is the termination prior to aided.
No, that aided there is no appeal. Appeal is, my lord, only on aided. That 83 circular is there, my lord, in the book.
No,
for a private college.
Yes.
No, for private college.
Aided college, my lord, 10-1.
Sorry, my. For private college, there is an appeal provision, and that appeal is before the director. And he has filed that appeal. Appeal has been rejected.
No, the only remedy was an appeal before the director, which has been rejected by the director on the ground of delay. Is it?
On the ground that
limitation, my lord.
Yeah, on the ground of limitation. Full stop. In other words, although the termination order was communicated no. See, this terminate ground that the appellant had resigned earlier.
Yes.
No, but he's disputing that she resigned.
Yes, there is a dispute. He is disputing that the Lordship may find it from Annexure 7 of the director's order. Yes, sir. So there is a dispute of resignation or termination.
Let it go back to the single match.
Yeah, that I am.
All right. The director rejected the appeal on the ground that the appellant had resigned earlier and her resignation had been accepted by the governing body. Full stop. Paragraph. Questioning the order of the director dated 17 September 2004, the appellant first preferred an appeal before the State Education Tribunal, which was rejected on the ground of non-maintainability. Then the appellant came to this court, first with an FAO, which was then converted on the orders of the court to a writ petition. No. You see, the petitioner then approached this court with the writ petition in August 2005. It was asked to be converted to an FAO on 29 September 2005. Full stop. However, this FAO was disposed of on 19 April 2010, asking the appellant to file a writ petition. And that is how writ petition civil 13637 of 2010 was passed. Paragraph. The impugned order of the learned single judge dismisses the said writ petition only on the ground that with the passage of time, the petition has become infructuous. Full stop. Having heard learned counsel for the appellant as well as learned standing counsel for the department, the court is satisfied that the appellant has never really been able to get redress in any forum against her termination order, and particularly in view of her contention that she never resigned from service. Full stop. At least one forum has to test the correctness of the termination order. Full stop. Although she may have attained the age of superannuation, if the termination is found to be illegal, the question of her retirement benefits would have to be addressed. Full stop. In that view of the matter, the impugned order is hereby set aside, and writ petition civil 13637 of 2010 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 2nd May 2023. The counsel for the School and Mass Education Department will ensure that reply is filed to the said writ petition.
It's a higher education.
Of counsel for the Higher Education, Department of Higher Education will ensure that reply is filed to the said writ petition by that date. So the learned single judge will have to issue notice to the other opposite parties in the writ petition before proceeding further in the matter.
Much obliged.
Considering that it is a 2010 writ petition, it will be open to the appellant to request the learned single judge in the roster bench for expeditious disposal of the writ petition. The writ appeal is disposed of in the above terms.
Much obliged.
Item number 6.
Please. I'm from PC Miller.
Yes.
And the fact of the case is that the petitioner, who is a retailer, who was given the kerosene and also the other food grains for distribution in their areas. And my lord, as per the law, and the petitioner was giving the and also other essential commodities to the beneficiaries, with the all sorts of valid documents and other things. The sub-collector all of a sudden giving a notice to the petitioner, stating therein that you have not shown your notice board in the outside of that shop room. So they get the reply, the petitioner the reply, and
so
stating therein that has already been mentioned, and the other things.
No, you have 1 minute. Mr. Rai, are you able to hear me?
Yes, Miller.
Are you? Is it okay to ask you a question, sir?
Yes, Miller.
This impugned order, 5th November 2019. Do you have that impugned order in front of you, sir?
Miller.
Is it an interim order, sir?
It is an interim order. That interim order, I filed the writ appeal for this, my lord, and honorable single judge did not grant an interim order in favor of the petitioner.
So then what happened after that?
Till that, nobody has given that supply of food grains to anybody else, and that is pending till that.
No. How does it help you to keep the writ petition pending? Will you not prefer that the writ petition is disposed of? You don't want the writ petition to be disposed of?
My lord.
What is the name?
My Lord,
There is one writ petition also 21033 of 2019. WPC.
21003. Yeah.
21033.
In that only the interim order and he's come and writ appeal. For some reason that
I
petition
see.
has also got tagged with this.
Writ petition copy is with me, but
Yeah. The tag, it's been tagged. So
Yes,
the writ
yes.
petition is not moving because it's got tagged here. You see the present writ appeal put to 583. Present writ appeal is directed against an interim order dated
High Court 2019.
5th November 2019, passed by the learned single judge. In the writ petition civil 21033 of 2019, filed by the petitioner, questioning an order dated 31st October 2019, suspending his license for supply of PDF/essential commodities for alleged violation of the licensing conditions in terms of the OPDS control order 2016. So the grievance in the appeal is that there was no stay of the suspension order paragraph. However, for over 3 years now, despite pleadings being completed in the writ petition, main writ petition, it has not progressed. In fact, for some reason, the writ petition paper book has been placed along with the present writ appeal, and therefore it could not proceed before the learned single judge. Paragraph. Given the nature of the order passed, which has been challenged in the writ petition, the court considers it appropriate to expedite the hearing of the writ petition itself, since pleadings are complete. Full stop. Consequently, while not interfering with the impugned order of the learned single judge, the court directs that the writ petition itself now should be finally heard and disposed of not later than 1st August 2023. For this purpose, writ petition civil 21033 of 2019 will be listed before the learned single judge in the roster bench on 26th June. On 10th May 2023, on which date the appellant will appear, as will the counsel for the opposite parties, state. The learned single judge is requested to proceed with the hearing of the writ petition in a time-bound manner and dispose it off and endeavor to dispose it off by 1st August 2023. The writ appeal is disposed of with the above terms. The main writ petition, that other writ petition is placed before the learned single judge in the roster bench on 10th May 2023, along with a copy of the order passed today in writ appeal 583 of 2019.
Item number 7.
Item number 7, outsourcing, that is similar to the
the batch specialist. All right.
Well, only one request. Yesterday I have talked to Mr. Advocate General, because in respect of outsourcing agency, government has called them for a discussion and they have withdrawn their strike day before yesterday. And I have talked to the Advocate General that I will be taking time, because they have been requesting to make a prayer before Lordship to wait for some time, because the decision may be within a week or two.
I have talked. He has requested me yesterday, and I have also talked with the department. The department says there is no policy decision in regard to regulation of outsourcing. What is the problem? You also may take up that will be urgent for a short file. I don't have any objection, but there is a problem. In some cases, contempt has been filed. Even if that license is not renewed of that outsourcing agency, honorable singulars are directing to employ them to continue in that.
Will not pursue the.
No, in that what is that? License of outsourcing agents are not renewed. The honorable singulars are directed them to allow them continue.
He says he won't pursue the contempt.
Well, I'll not pursue, my lord. Continue lordship's text of the amendment.
Adjourn for some time, my lord. That's the
whole record is statement. It doesn't want
yes,
to
ma'am.
that in the counsel the petition
contempt in
and all the specialist matters put together. He said the issue in all these writ appeals concerns the
not what has happened in writ appeal. Your lordship has granted stay. They have subsequently filed writ petitions. Subsequently, they have filed writ petitions that we are not.
The fact is slightly different, my lord. After your lordship is granted stay, my lord, they have allowed them to continue for 1 year because stay was granted in 21/2/2021, my lord. They have allowed them out because the contract was there. Subsequently, Finance Department wrote a letter in December, 28th of December, not to allow them. That way, my lord, they approached this honorable court, my lord, with a fresh writ application, interim order passed, and they have so far not, my lord, complied with it. And I will not pursue, my lord, that content.
You lordship observe that in that writ petition.
All right.
But not in writ.
The issue in the present writ appeals concerns the correctness of the impugned orders of the learned single judge, directing regularization of the services of the respondents, who are all engaged on outsourcing basis in various departments of the government. Paragraph, while issuing notice in these writ appeals, this court has stayed the impugned orders. Full stop. The effect of this was that the contempt proceedings filed by the respondents did not further proceed, although they were kept pending. Paragraph. Meanwhile, some of the respondents continued in service despite the interim order of this court, despite the interim orders of this court, since the term of the original contract of engagement had not expired. Stop. When they were sought to be discontinued after the expiry of the contractual period, fresh writ petitions apparently were filed by some of those respondents, in which again interim orders were passed by the
after their termination.
That's right. Interim orders were passed by the learned single judge. Interim orders were passed.
Yes.
Full stop. Counsel for the respondents, however, points out that those interim orders were not implemented.
Yes.
And the respondents were not taken back in service. Yes. Full stop. They have not filed contempt petitions.
They have filed in those cases.
No, I have not filed. I have not filed in that case. I have got that order for your lordships.
All right. Mr. Tripathi, appearing for the respondent, states that no contempt petitions have been thereafter filed by any of the respondents. Paragraph, be that as it may, he now states that the respondents have approached the government again with fresh representations.
No, through agitation to their federation, my lord.
Through the federation. And he expects certain negotiations to take place on the issue. Full stop. He accordingly prays for a deferment of the hearing of these writ appeals. Full stop. He further assures the court that the respondents will not be pressing, would not press for the hearing of any of the pending contempt petitions.
Yes, please.
Paragraph. In view of the above assurance, learned counsel for the state, appellant state, does not object to the request for an adjournment made by counsel for the respondent. Paragraph. List on 14th August 2023.
Prior to that,
look, they have assured. 5 of the members,
they have already a stay. So whoever has got out of service has gone out of service. Yes. There's already a stay granted by this court. So what? How can it hurt you? And he's made a statement that he's not pressing the contempt. That's all.
Government has to take on call, my lord. And they have assured me. They have assured.
It can.
My lord, 5 of the members were called, my lord, to me. 30,000 employees, my lord, were in the street. And day before yesterday, my lord, they have
called for this time. For 1 month, my lord, if not 14, so that any date before
you never know what the government might do.
Any date before 14th, any date, that is my
some time should be given to the government.
That I am saying, any date before 14th 8 in July.
8th August.
I cannot make a bargain with my lords. So I paid in July. I paid in July.
8th August 2020. All right. All right.
Item number 8.
That is 23 and special list. Serial number 20. 23 and special. And let them serve me copy of the Mr. Behra has never
The entire
served.
specialist gone.
Right.
All right. Your colleagues are all now worried. The whole board is collapsed.
Your lordship have enough work, my lord. Your lordship is indicated in the last occasion.
All right.
I would.
Okay.
Item 8
Also,
ಮೇಲೆ
item
ಸರ್ತ
number
ಪುರಿಡ.
23 in this list.
Item 23 also.
Well,
All right.
a copy of the write-up will be served in the meantime.
Yes, my lord, I am sorry.
All right.
Item number 8.
ಮೇಲೆ ಸರ್ತ ಪುರಿಡ. 8th May.
8th May.
Item number 9.
8 number 9 will data entry operator.
So it
Yesterday's list.
Tehsil.
Tahsil. Well,
So it will be part of the reserved matters. No, but none is appearing. No?
let's may issue notice. No, it's not a data entry. He's a peon.
Sorry?
Peon, my lord. 8. It's a different matter.
Yeah.
It is a different matter.
No notice has gone yet.
No notice has been gone.
Oh. So notice returnable. May 16th. Interim order. There shall be interim step.
Item number 10.
Sorry, my lord, sorry. Item 9 is a data entry after yesterday's matter.
No. First of all, is it before notice or?
No notice, it's a similar matter. Your lordship can 19951 that Patita Bhavan that case. That similar to that case.
I see.
That order is reserved in that respect. Social data.
No, but here notice has not gone. No? Mr. Tripathi was appearing. In this matter,
in honorable case.
you were appearing before the single judge.
That honorable.
Your BS Tripathi won, no?
Yes.
If you agree, then it can go back.
No, my lord, not go back. It will be tagged with that Patita Bhavan Das case.
That judgment.
Okay.
That I am.
So then you say orders reserved?
Yes, that.
And along with judgment will be pronounced along with the batch.
Item number 10.
Put down Tripathi.
Yeah, please. See, PL matter last occasion due to non-appearance, it was dismissed, my lord. The serial list was skipped for which it was not intentional, for which, my lord, next day I have filed this restoration petition, my lord.
On the very next day, he has filed.
Yeah. For the reason stated, the order is recalled and this writ petition is restored to file. What is the main writ petition?
Main writ petition is regarding the change of jurisdiction of revenue village from Odoga sub-registry office to
petitioner's representation bracket annexure 4 will be examined by the collector or
collector.
Collector, better. Collector Nayak.
Collector Nayagar, and after notice to the petitioners and giving them a hearing, the reasoned order shall be passed not later than 1st June 2023 and be communicated to the petitioners not later than 8 June. Court clarifies it is not explicit anywhere in the matter.
My lord, till then, my lord, sub-registry office which is at Odoga still remain there as earlier, my lord. Till
not now. No, can pass interim orders.
Because 1st April, my lord, they have in their notification, they have stated that after 1st April, the sub-registry office will function at Nuaga, which is at a 35-kilometer distance, my lord.
Can't be helped. Right.
Item number 11.
This post office in front.
Item number 12.
None appears.
Item number 13.
13 also.
The 1 week accommodation may be given. Some defect have been cropped up. Some
13 is it?
Translated copy.
All right.
I have not seen.
This is 21 matters, sir. What is it about?
I have challenged the ultra virus of the section 8 of Odisha Land Rights to Slum Dwellers Act, my lord. Although appeal has been provided, before whom the appeal is to be preferred.
No, where is the occasion, sir? Who are you, all of you? Sheikh Abdullah. What does he want?
Notice maybe should.
No. What's the matter about, sir?
The ultra virus of the section 8 of.
On what occasion? There must be some occasion, no? To challenge it. You run a social organization saying Basti Basinka Ekta Manch. All right.
Yes, my lord.
Awareness programs. So there's an order rejecting your application for issuance of the certificate. Where is that? Annexure 6 series.
Yes, my lord.
You have to challenge that order.
Your lordship may see Annexure 6 series. Page 33, my lord. Collector has denied rejected his application that he has no
power.
Yes,
who has the power to issue?
Lord, he has already provided in this section.
So you challenge it in a writ petition then? Why will you challenge the virus and all that?
Your lordship may see section 8 of the provision, my lord. Odisha Land Rights to Slum Dwellers Act. Subject to such rules as may be made an appeal from any decision or order made under this act.
Is it made under the act? I don't think so.
Yes, my lord.
No. It doesn't say that.
Shall lie to such officer as may be appointed by the state government.
Sir, this is not an order under that act, sir. Please come to page whatever, Annexure 6. You have simply given a representation saying grant me certificate. He has rejected that representation. That's all. Where do you get it that this is under this act and all that?
In pursuance to the order passed in the WPC number 280.
Where is that order?
The order is not. Pursuant to this order, the collector has passed this order, my lord.
No. What is that order? Who filed that writ petition? It's some Kusun Dey. Who's this? You're not aware?
I will file it, my lord.
You file a writ petition. Ask that Kusun Dey to file a writ petition. They are the agreed party. You see, it appears that the real grievance of the petitioner is about not having a remedy against an order dated 6 January 2021 passed by the collector Cuttack, rejecting the petition of one Kusun Dey, who had requested for grant of a certificate of land rights in respect of Hull plot number 97, Hull Khata 2122, Moza Chandni Chowk. Full stop. The order states that the collector does not have the jurisdiction to entertain the request. Paragraph.
Section 3.
The remedy, if any, for the said Kusum Dey was to further question the said order. In an appropriate petition.
Kusum Dey has already filed the writ application. Pursuant to that writ application, she filed a petition before the collector.
Correct. Once the collector rejects, she can again challenge the collector's order. Is to challenge the collector's order in appropriate proceedings. Full stop. The court therefore declines to entertain the present petition, rejected as a PIL. Petition is accordingly dismissed with the above observations.
We are appealing for the option number 1 in this case.
All right.
Item 14.
May I please, my lord? My lord, as regards, my lord, page 13, my lord. As regards fast para and fast prayer, it is fairly submitting, it is in, the examination is over. My second prayer is to give the employment to the local youth in the industry which are coming to the Odisha.
This is all very vague, sir.
My lord, Annexure 2. My lord, Annexure 2. My lord,
Quite vague and sweeping.
My lord, Annexure 2. My lord, can kindly say Maharashtra, 80%.
Yeah, that's all right.
My lord, I have.
These are all policy matters, sir.
Yes. I shall file a representation to the
All
authority.
right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a representation as far as the second prayer in the writ petition is
Yes,
concerned. Disposed of is withdrawn with liberty is prayed for.
Our appearance may be not.
All right.
Item 15.
Item 15, Lordship may kindly permit to withdraw to apply to application in proper format.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition in a proper format.
Okay.
Disposed of is withdrawn with liberty is prayed for.
Item number 16.
Item 16, may I please, Your Lordship. So, nature of PIL, my lord, in the Gochar land, Kisam land, over the Gochar Kisam land, the
the petitioner's grievance petition, bracket annexure 2, will be examined by the Tahsildar Balikada, and after notice, the petitioners and the CDPO and opposite party number 5, and after giving them a hearing, the reasoned order shall be passed not later than 1st June, communicated to the parties within a week thereafter. The court clarifies it is not expressed any in the matter.
Item 17.
Please, my lord, here, our representation is there before OP number 3 to meet.
Install tube well.
During the staggering summer, we are also facing.
All right. The petitioner's representation, bracket annexure 1, will be examined by the BDO Tangi. And after notice to the petitioners and giving the hearing, the reasoned order shall be passed not later than 1st June and be communicated to the parties not later than 8th June. The court clarifies it is not expressed.
Item number 18.
This is a PIL matter, my lord. We are challenging the construction of Pakka houses by the opposite party of 4 to 7 over Gochar land, my lord. And my representation is pending under Annexure 2, my lord.
All right. Petitioner's representation, Annexure 3 series, will be examined by the Tahsildar Tirtol, and after notice to the petitioners and opposite parties 4 to 7, and giving them a hearing, the reasoned order shall be passed not later than 1st June. We communicate to the parties within a week thereafter. The court clarifies it is not expressed any.
Item number 19.
Item 19, my lord, permitted to withdraw.
All right.
With the liberty to file better application.
All right. Disposed of is withdrawn with liberty to file a better application.
Item number 20.
Permitted to withdraw and liberty may be granted to file better application.
All right. Disposed of is withdrawn with liberty to file a better petition.
Item 21.
21, man, it's a nature of PIL and inaction of opposite party 2 to 4 for taking action against opposite parties number 5 and 6 for running an illegal red mud brick factory.
All right. Petitioner's representation by Annexure 3 will be examined by the Tahsildar Hawley. And after notice to the petitioners and opposite parties 5 and 6, a reasoned order shall be passed not later than 1st June. Communicated to the parties not later than 8th. The court clarifies it is not expressed.
For orders, item 22.
Okay.
Pursuant to the last order, the Tahsildar has submitted the information regarding the availability of the OEA case and submitting the letter with the Tahsildar has constituted a committee to search the record in the Tahsil office, and the net result is with reference to the letter on the subject, we have to submit here that as per your order, the team searched the case record thoroughly in the record room of this office at it is on.
Can it go on be searching, sir?
No, the above case is not traceable at present.
All right. So it's not traceable now. Let's get down to the matter now. What is it? Where is this land? What is this? We're going on for too long, sir.
May just
they can't find a file. They can't do anything.
Both of us are appearing in this matter. Let it remain on board so that.
Why? What is the matter? In fact,
this is a judgment passed by the.
I'm finding it very strange. They're hunting a file for how many hearings now? It is before me for how many hearings?
I can understand.
Ah.
Only let it remain on board. In fact, I'm very badly placed today. Tomorrow, day after tomorrow, anytime, I'll come ready. I'll be coming ready.
Let's be done with this, sir. This can't go
Our
on.
consistent case is, so the Tauji, in respect to which the other side is claiming title, doesn't face because it says Sthitivan land. The record that was your lordship directed research is the OEA proceeding on the basis of which they claim title. We say such a proceeding never existed. It was created and a certificate copy was obtained. And that was what actually your lordship directed, let them trace it out. But if they formed a committee, they can...
See, if something is it's like those weapons of mass destruction. If it was never there, we traced out.
Because the record is never there. That is the stand of the state government, that there is no such record.
The availability of record. This record, there are lots of litigation, starting appeal, revision, application, objection. This record was being called for by every authority. And we have got a certified copy from the register. Means there was a record out of which we have got the certified copy.
That we don't know, sir. These are human ingenuity.
that certified copy is not being disputed by anyone. That certified copy is not being disputed by anyone.
No. How otherwise why are we calling
that? That's the point. That's the point. Let them take further time.
Not by anyone. Mr. Mishra is clearly objecting to all those copies.
That's a point I can address your lordship, saying that they have challenged this in the revision, and the revision is still pending with the revisional authority. This point is taken up by your lordship and decided. But both the things, the annual single judge order to pursue the
2010 appeal.
Beg pardon?
2010 appeal.
Right, Lord. I can assist your lordship.
Let only 13th anniversary happen, not 14th.
Tomorrow, Lord. Tomorrow. Tomorrow is a holiday. I'm sorry. I'm so sorry.
31st is Friday.
Friday. That will.
So 3rd April.
Probably.
All right, 3rd April.
3rd, 4th, anytime, Lord. I'll be. In fact,
any day, your lordship.
We're badly placed today, Lord. I'm sorry. I beg excuse.
All right, 3rd April, sir. I'll say now Mr. Mohanty, Learned AGA now has states,
my lord,
that he has received written instructions to the effect that that despite thorough search for the record in the office of the Tahsildar Sadar Cuttack of the record in OEA case number 3699 of 1976 in the office of the Tahsildar Sadar Cuttack, the file is not traceable. Paragraph. In that view of the matter, there's no purpose being served in continuously adjourning this writ appeal, expecting the record to be produced. Paragraph. Mr. P.K. Rathal, Learned Counsel, appearing for respondent numbers.
I'm responding number. Private respondent.
He was the read petitioner.
The private respondents, that is the original writ petitioners.
Two.
Respondent, but two. Yeah. Two. States that he's in some personal difficulty today and seeks a short adjournment. List on 3rd April.
3rd April.
All right. 3rd April 2020. All right.
23 already. Item number 24.
24, your lordship, same order your lordship passed in earlier writ application. The file a review petition, the same new document has been, the same order may pass. The covered order.
All right. Same order. Right.
Item 25.
25 मतलब rehabilitation.
30th August. All right.
Item 26.
26 also rehabilitation.
Right.
Item 27.
Plus 27 may kindly be omit to withdraw minutes.
Disposed of is withdrawn.
Item number 28.
28 मतलब शर्त पड़ेगा.
8 May.
Item number 29.
29, a regulation matter, Your Lordship. Fixed to 25th June of 25th April, ma'am. 25th April.
Okay, 25th April.
Item 30.
20. Sorry, madam. 29 is regularization of junior stenographer. That's a different matter. Your Lordship has disposed of some similar matters that not covered under that. So in this case, notice has not been issued. Your Lordship may issue notice.
All right. Notice returnable. 10th May. Stay till that.
Item number 30.
30 also junior stenographer.
All right. Same.
Item 31.
The work charge employee 14th September.
14th September.
Item 32.
32 junior stenographer similar to item 30. Item 30.
Which is
10th May.
10th May.
Item 33.
33 my lord, promotion during pendence of vigilance case. That matter, Your Lordship, similar matters are disposed of in
First day.
This is the first day. Notice has not been issued in this case.
All right. Notice returnable 11th May.
Item 34.
34 my 25th April. DLR regulation.
Same in 35. 35, 36, 37, all same.
38,
up
39,
to 38.
40, 41, 42.
Up to 42.
My lord.
All right.
35 to 42.
Up to 42.
Right.
25th April. Item 43.
43 and 44 also regulation matter. Your Lordship, 25th April.
25th April.
Item 45.
45 my lord, work charge 11th September.
Item 46.
46 my lord, proceeding promotion during pendence of departmental proceeding. Notice to go, my lord. 11th. It is also first day display.
10th May.
Item 47.
47 my lord, job contract 49.
49.
Item 48.
48 also job contract.
49.
Item 49.
My similar matter, TBA, Your Lordship has granted. Yesterday's matter, notice has been issued that order has not been downloaded. I will give that number. Item 67 of the yesterday's list, my lord.
When is that listed?
Yesterday's list, my lord. That order has not been downloaded. Uploaded, my lord.
Some date must have been.
That is 12/7, 12th of July.
12 July. All right.
Notice has been issued and the stay has
Notice and stay. Right.
Item 50.
50 my lord. That direction has been given for regulation that they don't have possessed the same qualification. Requisite they have not possessed, but it has been disposed of to it a direction that is similar to other cases, but is not similar because they don't possess that minimum requisite qualification. Here, my lord, notice it to go, my lord.
All right. Notice returnable. 13th July.
Well,
Item 51.
51, 49, what charge?
49. Right.
Item 52.
Your Lordship, appearing on VC, Your Lordship.
Yes.
Your Lordship, item 52, Your Lordship, I'm suffering from high fever. Your Lordship, kindly put up any other date.
All right. Counsel of the petitioner stated be unaware. 21st June.
Item number 53.
None appears dismissed.
Item number 54.
May I please, Your Lordship? Order of the learned single judge is not challenge, Your Lordship. That is Annexure 3. Your Lordship, fact is very simple. That is, Annexure 1 is the ROR. That is record of rights. There is a column 6, Your Lordship will see. There are, of course, in Oriya vernacular, that land cannot be transferable. That is in column 6. Now question is, that is to be deleted. Who is the competent authority to delete that? And
Once we've been relegated to 15B, sir.
No, my lord, that is not for that reason, your lordship. Earlier, one of these tenants come to this court, that is Annexer 6. Your lordship will see the same issue, your lordship. And that has been decided, no, Tahsildar is competent. That order I have given, but learned single judge has not dealt that. Then government order, your lordship, has written to all collectors of the state that no, Tahsildar is to decide this issue. Then your lordship will see Annexer 12, where collector has issued letter to all the Tahsildars of the district, that is, you have to adjudicate this matter. That has not been taken into consideration. That is on merit. Now on technicality, your lordship will see, in the first day, your lordship, learned single judge passed order that you serve the extra copy to the standing council who will obtain instruction. Without instruction, your lordship, that case has been disposed of.
No, but you've got relegated to section 15B.
15B is not applicable. That is in view of your lordship will see, that is Annexer 8 and Annexer 6. Thereafter also Annexer 9, earlier this petitioner has come to this court. Your lordship, with your lordship's permission, I am placing Annexer 9 of the writ petition, not writ appeal, your lordship will see. That is paragraph 3, page 49. Which your lordship's permission I am placing. The petitioner in this writ petition has prayed for a direction to the Tahsildar Mithali opposite party number 5 to delete the entry in column number 6 from the ROR under Annexer 1 published in his name. Entry in column number 6 of the ROR under Annexer 1 disclosed that this land is not alienable. Then your lordship, Annexer 4 is the government order he has cited, that is learned single judge. Earlier when I came to this court. And thereafter this honorable court disposed of the writ petition that you approach the Tahsildar. Then I approach, that is Annexer 10 to the Tahsildar. Tahsildar has passed this order that no, you approach under 15B. That order was under a challenge before the learned single judge. Learned single judge, without obtaining any instruction, that has been disposed of.
No, Tahsildar's order can be challenged under 15B. My lord.
No, that is in case of your lordship, suppose that is shortage of area or any error in the name, caste, etc. But not in respect of column 6, whether that land is transferable or not, that is not the purview of that assistant settlement officer or settlement officer under 15B.
No, settlement officer is not to exercise 15B. He is wrong. The commissioner is to exercise. If there is any error in the recording of the, you are saying that such a recording in the remark column is an erroneous. Then you, what is the wrong in it? You are not remediless. You have to approach the 15B before the commissioner.
That is your lordship. That is in contrary to Annexer 8, Annexer 12, and also ratio.
Annexer 8 does not discuss the 15B at all.
My lord, that is your lordship, with your lordship's permission I am placing. That is
what prejudice is going to be caused? Then your lordship can permit them to apply.
No. Annexer 9, which is what you are reading. 7.
My lord, Annexers, no, I am Annexer 8, your lordship.
All right, let's see.
8.
Your lordship.
Yes.
Now your lordship, kindly see, only relevant person. Paragraph 5. Subsequently, Orissa Government Land Settlement Act, page 46, your lordship, I am placing. Annexer, that is paragraph 5. Subsequently, the Orissa Government Land Settlement Act 1962 was further amended during the year 2009 to substitute earlier provision of settlement GKP category of land, Gramakantha Parambakal, that is GKP category of land, along with Khasmal, Najul and Abadi category land. The new provision now provides the permanent settlement of such land wherever situated or used for the purpose of heritable and transferable right with the person who is in occupation of such land, either on the basis of lease or otherwise, for a period at least 3 years prior to 26 February 2009. Then your lordship kindly see, that is paragraph 8. Next page, that is page 47. So the person in occupation of GKP, Khasmal, Najul, category of land has to file application for settlement of the same for the purpose of which it is being used, which shall be disposed of on merit following the procedure prescribed in Schedule B or Schedule BA. as the case may be. If the applicant is otherwise eligible and land qualify for a settlement on the respective schedule, the land shall be settled permanent basis with heritable and transferable right with him, and fresh rent will be issued in his favor accordingly. Lordship, this is that. Thereafter, your Lordship, kindly see Annexure 12. Annexure 12, your Lordship, page 56. That is, your Lordship, to Tahsildar in the district, that is Collector Koraput has issued, subject forwarding letter to all the Tahsildars of the district, then your Lordship, 56 is the contents. To all Tahsildar in the district, subject deletion of note, yehi jami hastantara yogya nuhe, recorded in column 6 of R1. Sir, Madam, Sir, in enclosing here with a copy of the letter number 1902 dated 29/11/2019 of the Revenue Divisional Commissioner, Southern Division, Orissa, Barampur, I am to request you to follow the instruction contained in letter number such, that is Annexure 8, your Lordship, that letter. 21st December 2018 of Government in Revenue and Disaster Management Department, Orissa, copy enclosed, and ensure all such application and cases are dealt with strictly as per rule within the deadline. This is the letter.
You say the impugned order of the learned single judge declines to interfere with the order of the Tahsildar challenged in the said writ petition, entirely on the ground that the appellant has an adequate, efficacious remedy under section of revision before the commissioner of what is this commissioner of?
Survey and
settlement under the Orissa Survey and Settlement Act.
Under section
15 bracket small b of the Orissa Survey and Settlement Act. Bracket OSS Act. Counsel for the appellant sought to suggest that such a remedy is not available in view of the fact that earlier a writ petition had been filed, which had been disposed by the appellant, which was disposed of by a single judge, pursuant to which Tahsildar had passed the impugned order. A perusal of that order of the learned single judge reveals that there was no occasion to discuss section 15 bracket small b of the OSS Act, and the matter had been simply relegated to the Tahsildar to decide the issue. Paragraph. Having heard learned counsel of the parties, the court is not persuaded that the learned single judge has committed any error in relegating the appellant to the remedy under section 15 capital B of the OSS Act. Consequently, there are no grounds made out for interference. The writ appeals are dismissed. Put both matters together.
55. Item 56.
56. In the meantime, file
original document may be written so that I will approach before the revisional authority.
The registry to return original documents to the appellant. Counsel for the appellant subject to being substituted with attested photocopies thereof.
In this case, appellants already filed civil suit before the concerned court.
In view of the fact that the appellants have already filed a civil suit in the concerned court, counsel for the appellant seeks to withdraw the present appeal.
Original certificate copy may be returned. Original certificate copy filed.
All right. The originals be returned subject to being substituted with attested photocopies. Disposed of is withdrawn with liberties with in the above terms.
Item 57.
57 relates to yesterday item 68 matter, similar matter. Yesterday 68 also affected all the cases to 14 July by issuing notice. Item 68 to yesterday list matter. That review order in part with the notice to us.
58.
Item 68 yesterday list. 57, 64, 65. All three.
Today is 57, 64, and 65.
My lord. Yesterday item 68 are there.
All right. They was yesterday's item 68. All right.
12 July. Item 58.
58 workshops 14 September.
14 September.
59.
59, I will remove the defects.
All right. List on 3rd May, defects we removed in the video.
Item 60.
It's Annexure 6 is under challenge. I am the college. I was opposite party number 5 in the writ petition. Without giving me a chance to even to file a counter, on the day one, orders of regulation has been passed.
Who's for the other side?
Other side, nobody has appeared.
Yes, yes, I appeared. The OA was filed 2017. Several charges were given, no counter by government. The college has nothing to say. Now, in the meantime, government directed to comply the order. And this is my order.
And the college.
Yes, and this is my order. The higher authority directed to comply the order.
He's not been heard, sir.
My lord.
He's not been heard.
They have been given 5 years chance to file counter, no counter file. 5 years, my lord.
Right.
2017 matter, tribunal issued notice. They are transferred to this court. This order twice directed, no counter, my lord. Tribunal directed, this one directed to consider regulation service because others have given the benefits. And in the meantime, directed to comply the order. And college has nothing to do. They have only to simply to regularize. Then the higher authority director, government director to comply the order.
The college has nothing to do. He works under me. I have to compare whether both the employees are two sets are situated on the same mallet.
You are given 5 years chance. Minimum 10 chances given, no counter.
My instruction is that he could not be because he did not have that qualification. He could not be regularized along with others. So at least let me be given an opportunity to file my return.
No, but apparently it's a 2017 matter, sir.
Yes, my lord.
My lords. In the
where is this communication showing?
My lord.
You say they've been directed to comply.
My lord. And in similar matter also, my lord directed to regularize services because of long continuous. That is what you will also for. In similar matter, my lord directed to come to I'm giving copy, my lord. Second copy.
What did you do in the other writ petitions?
Others have been stayed by two other writ petitions were there earlier. Your lordships have stayed that.
Oh, when are those coming up?
They are all coming up in the month of May.
When?
I have not even I filed my power. No.
Notice has gone to. Notice has gone.
No, this was the writ appeal?
Yes, similar matter also dismissed the because long continuous matter directed regulation services. Similar.
No, not this matter.
Not this similar. I have said similar matters.
No, I'm talking of the other two connected writ appeals.
I have not appeared. I have not.
Lordship has issued notice.
Where is the order, sir? And there must be a date. If there's an order, there must be a date.
I'll supply the.
We'll pass it over then. We don't want to put it on different dates. You pull out that order. Pass over.
Lordship, pass it over. I'll file the.
Yes.
Item 61. Lord, state is the appellant. This is regarding payment of insurance, crop insurance. The data has been supplied by the respondents, but which is contrary to the scheme. That is a factual controversy, and we have paid according to our scheme. The Honorable Single Judge has said that according to the data supplied by the respondent, you have to make the payment. This is the only dispute. Lordship may admit it, and we have already paid them according to the scheme. And my stand in the counter affidavit has not at all been taken care of. Nothing has been elaborated or discussed in the impugned order.
No, what is the financial outflow as a result of the impugned order?
They will be entitled to get the differential amount beyond the scheme.
No, but how much?
Yes, that is not borne out in.
I think we'll find out. Counsel for the appellant state seeks some time to ascertain the financial implications of the judgment of the impugned order of the learned single judge. At his request, list on 17th April.
Obliged.
Item 62. 62 my lord, job contract 14.9.
14.9.
63. Item note 63.
All right. None appears dismissed.
Item 66.
This item 66, 67, and 68, they are connected to the earlier.
I mean 65.
65 to Higgins. Somebody mentioned.
65 is different.
64 and 65 already taken up now, along with item 57.
66.
It was taken up with 57, sir. 64 and 65. And when is it listed now?
From 12/7 or 12th July.
12 July it's listed.
66, 67, and 68. Yesterday, your lordships are fixed to 24th July, that batch met.
24th July. Notice longer.
In item 69, I pay 1 week time to file my certified copy.
69.
Certified copy I have not filed. 1 week.
All right. You say list on 3rd May, defects will be removed in the meanwhile.
Oh, please.
Item 70.
Item 70, job contract 14/9.
14/9.
71.
71, my lordship, see, input order is at page 22. There, my honorable single judge has directed to regularize them for a particular date, though our scheme does not say so. Our scheme says on completion of 10 years, appointment must be prior to 12/4/93, and after completion of 10 years, taking into account the vacancy position, they will be regularized. But by misinterpreting that scheme, the honorable single judge has directed when he has completed 10 years, he has to be regularized from that date. I give that scheme, my lord, before my lords, that has not been annexed to my writ appeal. I'm giving that scheme has been framed in pursuant to direction of the honorable apex court, and that scheme particular that scheme is 15 May 1997.
Yes.
Shall be prepared by the appointing for each category of worker, determine the length of particular persons. The worker should have worked under the administration of the department concerned directly for a minimum period of 10 years. 10 years is the eligibility criteria, and the first appointment must be 12/4/1993. On the gradation list will be prepared, taking into account the vacancy position, they will be observed subsequently. But the honorable single judge has said, since that is the 10 years, that is the minimum eligibility criteria, when they have completed 10 years, you regularize them from that date.
All right. It's a notice returnable. July. Stay till then.
Item 72.
72, 73, 74, same.
18 July.
Item number 75.
75 DLR 25th April.
25th April.
Item number 76.
May I please, Lordship?
Come here.
The question in this writ application arises for your Lordship's consideration is the limestone, which is imported by the petitioner company for industrial use, that is for manufacturing steel millers, can at all be covered under the plant quarantine order 2003 millers under the Destructive Insect and Pest Act 1914. But your Lordship millers, I will take your Lordship's attention to the order dated 6/10/2006, a detailed reason order. A bench of this order was passed in this case, millers. Kindly see millers order dated 6/10/2016 millers.
Right.
I will start from paragraph 6 millers.
Yes.
The petitioner is engaged in manufacturing of steel, and for that purpose, it imports limestone, which was never included in the plant quarantine regulation of import into India order 2003, insert quarantine order 2003. Limestone was not covered by the notification dated 26/6/2014, Annexure 8, but chalk was added as an item to be covered under the quarantine order 2003. Then, by notification dated 23/6/2016, certain other items were added and chalk remained as an item to be covered by order 2003, but limestone was not mentioned as a covered item. The petitioner is aggrieved by the act of opposite party number 4, by which the petitioner is required to comply with the quarantine order 2003 for importing limestone also. On having received instructions, Sri Bose Learned Assistant Solicitor General has accepted that though limestone is not covered by notification issued under the quarantine order 2003, but by a communication of the Minister of Agriculture, dated 12/7/2016, in between chalk and salt, the mention of limestone has also been made, and thus it is treated to be included. The submission of Law and Counsel for the petition is that by an administrative instruction, nothing more can be added to what has been notified by the government, and such inclusion of limestone is not in accordance
Who's
with
appearing for these opposite parties? 1, 2, 3.
Union of India ASG, Deputy Solicitor must be appearing.
Where is he? Yes, Mr. Bera.
Malats, I am there, Malats. May I inform Learned DSJ is leading us in this matter?
All right.
If you're, I would request my learned senior to kindly allow me, because I have not been assigned with this one, Malats.
That's a difficulty.
One Passover.
I have been protected by your Lordship's order, and for last 7 years also there is no difficulty because your Lordship protected me. Not only that, your Lordship was pleased to be able to say that petition not be subject to quarantine process under the quarantine order till the next date of listing. It is up to today, my Lordship. Your Lordship kindly extended, and I have filed a formal rejoinder also. My Lordship may take in to record.
The rejoinder is taken on record. The learned DSGI appearing for the respondents is stated to be opposite parties is stated to be some personal difficulty today.
His name may be reflected. It's not in the list also. What I find.
His name also be reflected in the cost list. List on. 29th August. Interim audit country.
If you want to continue, Ross. But I will not pray for anything except that can it be little? It can be disposed of within 5-10 minutes. Just only my humble prayer. Or I will not. Otherwise, I won't have.
It's all right.
My Lords.
Item note 77.
May I please, Lords? My Lord, this is the case for the proceeding by the NSR 3 series, page 48, Your Lordship. A proceeding was initiated on the basis of the final order of the state level scrutiny committee. And that committee report was challenged before this Honorable Court by the NSR 2 series, page 36, Your Lordship. That was quashed by this Honorable Court and remanded it back to the committee for de novo inquiry. Your Lordship, since the criminal proceeding is still pending, Your Lordship, it may be quashed till the decision of the committee report.
This is 115 of 2017.
Read petitions, WPC. No, this is not 77.
77
is something else.
This is WBC 115 of 2017.
Correct.
And it's pursuant
My
to
Lord,
your last order.
I am there in 77.
My Lord, my friend.
My Lord, I am appearing for the petitioner, my Lord.
So the
my Lord, the Lordship's order has been complied with. I should be thankful to my friend Mr. Mohanty, who has been helpful to the deaf school, and it has been upgraded. Only some small submission, Lordship may observe in the order that the yardstick with regard to appointment of teachers and other facility may be followed up.
All right. You see, it is now confirmed that the order passed with this court has now been complied with, and the school for the deaf Noapada has now been upgraded from class 7 to class 8.
Class 7 to class 10th, man.
To class 10.
Yes.
All right. Paragraph, it is expected that all other norms, including teacher strength, is it? Staff strength?
Yes, my Lord. Yes, my Lord. Yes, my Lord.
Teacher and staff strength applicable to the school in question will be strictly complied with. All right. No further directions are called for. The petition is disposed of.
Great. I'm grateful, my Lord. I'm so obliged, my Lord.
Item note 78.
May I please, Your Lordship? This is a public interest litigation, my Lord. 42 lakhs have been sanctioned and utilized for purpose of construction of an old age home and handicapped home that has been used for a commercial purpose for a hotel, my Lord. That is what the only allegation. The money sanctioned, building made, not a single old man was allowed to remain inside. It was used for commercial purpose.
Who is this? What do they say in the counter?
Counter, my Lord. They say they have been utilizing, they have charitably, they have been distributing prasad to everybody, all these things. That was not the purpose for which money was sanctioned, my Lord. It is the old age center for the purpose of giving shelter to the old and the handicapped. And page, Your Lordship may see Annexure 3. 3 is very clear. Annexure 3, page 19. The Right to Information Act, I obtained the instruction. And the page 20, Your Lordship may see the purpose. Project name, Common Center for Old and Handicapped of Hanuman Vatika. Then the amount of money sanctioned, my lord. And they say always there is an old age home for construction and finishing, all these money have been utilized. Since 2001.
No, but if you see the counter affidavit of opposite party number 2.
Yes, my lord.
Yes, ma'am.
They admit. They
No,
say
come
that.
to para 9.
May I read, my lord? That the abhorrments made in para 4.2 and 4.5, the repetition is admitted. And it is respectfully submitted that as per the guideline of Ministry of Statistics and Program Implementation, the members of Parliament Local Area Development Scheme is to development works and creation of durable community assets. Since the members of the Parliament have recommending role and district authority to implement so-and-so, as per recommendation of the land fund, so-and-so, one common shelter for old and handicapped Hanuman Vatika Raurkela was constructed, amounting to rupees so-and-so, and others CD, different phases money have been sanctioned. But that was admitted.
No,
They also said,
not same.
in second, an old age home was constructed amounting to rupees 4 lakh. Then in C, rupees 3 lakh was spent for completion of old age home in Hanuman Vatika Raurkela. D, and also rupees 5 lakh was utilized for the further construction of old age home, including sanitary installation, water supply, sewerage, etc. from Sri Dilip Rai MP lads. The aforesaid work was constructed satisfactorily and executed properly at Hanuman Vatika by opposite party number 2, Raurkela Municipal Corporation, in the year 2000-2001. It's relevant to mention here that only the construction of the said old age home was under the administration of RMC, and there was no condition for maintenance of old age home. As such, the allegation by the petitioner so-and-so, false and so-and-so. Look, they are to construct, no doubt. OP number 1 is maintaining. Look, they got the land from government in a very cheap rate. And the purpose was to construct the old age home. How can it be converted and used for a commercial purpose?
No, where do they? This whole paragraph doesn't talk of any commercial purpose. It talks of all the homes. It talks only the old age home. This whole paragraph 9.
One common shelter, this 9A, common shelter for old age and handicapped for Hanuman Vatika was constructed.
So where are they admitting that it was for a commercial purpose?
Oh, no, they don't admit. They say that we are this is OP number 2 has filed the counter.
Correct. OP number 2 is Rourkela Municipal Corporation.
Yes. They say we don't have any authority over the administration, how it runs, my lord. They just shifted their responsibility.
No. Your allegation is the land is meant for an old age home.
Yes.
It is being used for a commercial purpose.
So by the opposite party number 1, my lord.
No, but obviously opposite party number 2 will know whether or not that is correct.
No, they say that we have been asked to construct the building without any administrative authority, my lord. They say like that, my lord. We don't have any responsibility of maintaining the same. They admit construction, well, they admit the purpose.
Well, in this case, I am for the opposite party number 2, my lord. As per the allotment, we have constructed the old age rooms, my lord. But
counter. 7925 is the number. They put 7905. Yes.
As per the allotment from MP land, my lord, we have constructed the old age rooms.
No, he's saying some land is now being used for commercial purpose. Is that correct?
That I cannot say, my lord.
Why cannot you say? It's same Rourkela, sir. Why can you not say?
Construction of that is.
No, that government, which paragraph of the writ petition is that government?
My lord, perhaps the lawyer appearing for the OP number 1 is not present, but he has filed a counter affidavit.
No, he has. Yes.
Copy number 1, para 4. This petitioner is a hotelier. He is having a hotel near the Hanuman Bhatika. These are all inside the Hanuman, and due to his personal interest, it says here, that is what he has mentioned in para 4.
Look, that is what I have filed the rejoinder. How can my learned friend say that I am a hotelier?
I am not saying.
Hotel, small hotel in the name of my wife has been running since 1990, 1 kilometers away from the particular place. And he has got it rented from the BDA, RDA, Routledge Development Authority. A small, doesn't have any nexus with this. My specific government is that this purpose for which land was allotted by the government is for the purpose of construction of an old age home. And now they say that they have been utilizing, by the counter they admit they have been utilizing the land, but distributing prasad, seven, temporarily somebody is taking, but they have been using it for commercial purpose. I have given the photographs, my lord, in the writ petition. Page 9.
So how can RMC not, which is the para in which you've given that government about commercial purpose?
Commercial purpose, my lord.
Which paragraph you've writ petition?
My lord. My lord, paragraph 1 itself, your lordship may see. The present petition under Article 226 of the Constitution of India being filed by the way of public interest litigation.
So how can you say it is not known, sir? Yeah, RMC, look at the para 7 of your counter affidavit.
But in the Raulkela municipality, only the executing agency, my lord, he has, as per the MP lad, my lord, he has constructed the old age home, my lord.
No, misutilization of government land for commercial purpose. How can you say you do not know? You are the Raulkela Municipal Corporation. How can you claim that you don't know? The allegation is the land is being used for commercial purpose when it was meant for an old age home. And you say don't know. One of the main allegations in the writ petition is that land which has been earmarked for the purposes of construction of an old age home is being used for commercial purposes. Full stop. Strangely, in response to this argument, the Raulkela Municipal Corporation, RMC, has filed an affidavit claiming that it does not know whether such alleged misuse has occurred. Paragraph. The court finds it strange that the RMC would not know if there's misutilization of land by an entity. In this case, opposite party number 1. A supplementary affidavit will be filed by the Commissioner RMC specific to the averments in paras 1, 2, and 3.
Para 1 is
in para 1 of the writ petition, as well as the photographs enclosed with the writ petition. The supplementary affidavit of the RMC be filed positively on or before 1st May 2023 with advance copy to counsel for the other parties. List on 16th May.
What's 60 are passed on the orders. Passed on the connected.
All right.
Great. 15th of May. So coming on 15th.
May, is it?
15th of May.
All right.
2 cases are passed on both the orders. 2 copies of each other.
Right. All right.
This be tagged on the same. Great.
Item 79.
Ma'am, there are 2 writ petitions by the same petitioner, and both are interconnected. And so far the WPC 12460 of 2020 is concerned, if that is allowed, automatically the present petition will cover. And in the event that is not allowed, then the present second writ petition, subsequent writ petition has to be taken into consideration for the prayer made there. Here, if a lordship will see the prayer made in first writ petition 12460 of 2020.
You want direction to them to acquire the rest of the area of the revenue village.
Yes, yes. The basis of this thing lies, my lord. Here, 90% of the village has already been acquired. Mining is going on. And there are around 7 to 9 villages in the locality where, in view of the resolution in question, which I placed before Lordship, the 100% have already acquired as per their own decisions. And 1 and 2 villages are there because they are, as per the agreement, they are not able to provide the rehabilitation so far the residential area is concerned. Even though 90% are acquired, the rest 10%, they have been allowed to enjoy the houses. Here, the fact of the case, your Lordship kindly see the basis on which the writ petition has been filed. In fact, they should have come much earlier. But the delay is not taking away their the right. But the whole point is that because the acquisition of the land, a large number of people were provided employment, they became afraid, even though they are suffering for about more than 2 decades or 3 decades now, that least if they will go against the MCL, their children may be transferred, which is very natural in our system of administration in the state. State means I'm not confining to the state of Orissa only, state as a under article. Well, so the whole point is that
these are villages in Anugul, is it?
In the district of Anugul. Your Lordship kindly see.
What mining is coal.
This is the Talcher coal mining is one of the oldest coal mining during the British time, more than 100 years, and this is the hottest place in the state.
So only these 4 villages have been left out?
No, this is only one village.
One village.
Out of 8 to 9 villages, 7 villages are 100% taken on the basis of this proceeding. Your Lordship can see.
Das,
your Lordship can see the proceeding.
You normally have petitions saying don't take away land. Here it's a reverse. They're saying please take our land.
Whole difficulty, my lords. This is not required for mining purpose. I have filed a map. The mine has traveled more than 3 kilometers away from this village.
No, Mr. Das, what happens is all around, if the mining activity is taking place.
No, it's not correct. Not correct. I have filed a map.
Do you have a map? Do you have a map?
I have filed a map with my counter.
Where is that?
My friend has taken thrice time to file a rejoinder. No rejoinder has been filed.
Where is the map?
Along with my counter, Milord. I by 5, I think it is page 131. Page 131. I filed an exhaustive map, Milord. This is not required for the purpose. And the reasonings I have also given in the counter. It's a very big map.
No, 131 in that first writ petition.
No, my counter affidavit.
That's right, in your first writ petition.
1246. 1246.
Ah, that's what.
Page 209, I think. Running page 209.
No, right. Last. Right side.
More than 9 is something else.
No, I have filed the map.
Give us the annexure number.
Annexure I by 5.
I by 5, I think.
I by 5.
Yes, Milord.
That I think has not been scanned.
I think it is a big map, Milord. It is a big
scanned.
map.
J is there. I is not there. Between H and J, there's I.
It is a double full scale size paper.
Very good. You have a copy of this map.
That I have got the map. That map has got nothing to do. If your Lordship will go through the amendments, that will not prove anything in view of the amendments made in the writ petition.
Because counter has some role to play.
Almost it is a evasive counter, and if your Lordship will send.
But why are you not filing rejoinder then?
Milord?
Why are you not filing rejoinder?
He has taken thrice time.
No, the whole point is that I wanted to file a comprehensive rejoinder in the event the central government has taken also 3-4 times to file a counter affidavit, because they have also got a major role to play. They have also not filed any counter affidavit. It is not that, if your lordship will see, for a moment, my lord, here that their own annexure 2 for a moment, your lordship kindly see. The entire averments, if it is one, iota of it, if is found to be true, your lordship may throw away the repairs. And if an expert committee will be sent, they will virtually see in a situation, hell-like situation, the villagers are staying around the 8 to 9 villages. Not a word even can be said to be baseless. And something.
That's under the map. Danara is literally in the eastern corner.
No, that has got no nexus with the case, the grievance. The whole area, my lord, your lordship kindly see for a moment annexure 2, the basis of which the petitioners have approached your lordship. The state has your lordship can close
file a rejoinder.
Yes, your lordship can close the filing of counter affidavit by central government. Then it will take it as an expertise, because they have been taking time.
Expert in all. No. Central government be expert
on ground of non-premise, because at the late time again they will come. That is why to avoid repeated.
But central government you are there for central government.
They have taken time repeatedly. Last occasions, all previous
for
occasions.
Central government, on behalf of Sri Bimbisar Das, I am there.
Milord, Union of India, OP number 1.
Bimbisar Das, I see. All right.
On behalf of OP number 1, last all occasion consistently they have taken to file counter affidavit. So only when the counter affidavit is filed and complete.
You say counter affidavit by the MCL encloses a map in which it is attempted to be shown that the Danara village is around 3 kilometers away from the mine. And therefore, the land therein is not required by MCL. However, this is strongly disputed by Mr. H.S. Mishra.
On the fact that
the petitioner stating that
90% of the same village has been taken for coal mine.
All right. Even a field visit to the area will reveal that more than 90%.
Yes, about 90%, 87 something.
Of the village area is already
taken for mining.
Full stop. These are clearly dispute questions of fact. Paragraph, Mr. Mishra offers that before the next date, irrespective of the central government filing its reply, he will file a rejoinder. Paragraph, a last opportunity is granted to the central government to file its reply to the writ petition on or before 1st July 2023. Rejoinder will be filed before the next date. This is
maybe listed
12460.
First week of August, man.
All right. 9th of August. All right.
9th of August.
Right.
Item number 18 for the OP number 11, my lords.
14984, list along with that one. 9th of August. All right.
I'm appearing on behalf of OP number 11, my lords.
Old mine is 3 kilometers away. Then what made them to acquire 90% of the same village? My house is 4,000 square feet. 3,000 square feet will be taken on 3.5, and 500 is away from 300 kilometers. It on submission absurd is itself is absurd.
No, 3
No,
I think the
house
argument is absurd.
out of the house.
May I submit minutes for 1 minute?
It is not a submission on merit. It's out of the court.
I am also submitting. I have a right to submit.
Yes, you have
the purpose is that area is not required. That is a basti area. There is no mining activity. There is no mineral inside it. They want to acquire that so that they will get very, very high compensation. That is the entire purpose. Even if it is not required for us.
All right.
Item number 80.
Item 80, I am appearing for the opposite party number 9. My lord, can see last order dated 5/12/2022. Paragraph 2, my lord, directed to shop the copies of counter affidavit which are filed by the respective opposite parties on till date, except the counter of opposite party number 5. I have not received any counter.
Yes, counter means the Union of India has filed a counter.
Yes.
And that
he does not have a copy.
Lord, I am also appearing for OP number 5. Lord, I have also not received the counter filed by the Union of India.
Your Lordship will kindly permit to appear the virtual mode, Your Lordship. We'll file the counter within a week. We'll serve the copy. We'll file the counter, we'll serve the copy within a week.
Counsel appearing for Union of India shows that the counter affidavit will be filed within a week with copies to counsel for the other opposite parties as well as the counsel for the petitioner. Counter affidavit already filed of other opposite parties be served on the respective counsel for all the parties. Joined to the counter affidavits.
So I will file a
rejoinders oblique responses to the counter affidavits to be filed before the next day.
So far, my lords, opposite part number 11 is concerned, I will take notice.
All right, he takes notice for. Oh, but you are also the petitioner.
I am the petitioner.
Fresh notice be issued to opposite party number 11.
Requisite I will file within 7 days.
Returnable on the next day. 22nd August. Right.
22nd of
August. Item 81.
One is regarding the construction of road, the government council have to apprise this honorable court about the status of the road. As per my instruction, it is 1.7 is already constructed, Miller. 400 kilometers are left.
400 meters.
Miller.
Not kilometers. Kilometers or meters?
Meters.
Meters.
Yes.
You said kilometers.
400 meters.
Counsel, the petitioner states that the road has been constructed up to
1.7.
1.7 kilometers.
Yes.
And only 400 meters are left. Counsel for the opposite parties will. And now you'll have to say something.
Yes, my lord. I have received certain instruction. Yes. With reference to the cited and continuing not. It is stated that the road work could not be completed within the time as committed by this officer with reference due to standing crop on the road vicinity and some local land dispute created by the villagers. However, the work will be completed by end of February 2023.
Over. We are in March.
That is the instruction which I have received on 8th February 2023.
All right.
Last time this is also.
All right. Mr. Mohanty seeks some more time for instructions. He expects the work to be completed by end April.
End of February 2023.
Now you have to say end of April.
Yes,
sir.
that again I have to.
By end April 2023. List on 17th May.
Item 82.
Yes, overlay.
This is a PL regarding the paternal retribution matter. And on the last order, my lord directed them to file affidavit about the timeline for completion of project and starting and completion. They have to file affidavit.
Yes.
They are not till then not filed any affidavit.
7th February, we have filed the complaints affidavit. Yes. Lordship may see the complaints affidavit dated 7th February.
7th February?
February 2023.
You not served a copy, looks like. You got the 7th February order, affidavit.
Below 7th February, they are given a copy, but they have neither whispered any as per my lord's direction. They have not whispered.
No,
when it will be started, when it will come.
No, para D, sir.
Para D.
Last page. It is expected the execution of work will be started by April 23.
Started. Your lordship direction. My lord,
timeline
when it will be started, when it will be completed, because
my lord,
they have only earlier argument that we have protect tenders.
Let me impress your lordship that it is a very big work. Your lordship knows in CDA paternal project, my lordship also.
But it's all the more better than to have a timeline. No?
Yes. That after the work is properly, the agreement is executed, that agreement itself will give a time bound.
When is the agreement going to be executed?
That.
All right. You say the affidavit filed by the state on 7th February 2023 indicates that the tender process is still on and the execution is expected to commence in April 2023, Mr. Mohanty, AGA, informs the court that once the agreement is signed with the contractor, the timelines will become clear. Paragraph, a further affidavit setting out the timelines be filed before the next date. List on 5th July.
Item number 83.
Maybe pardon to Summit Miller, that is the construction of a foot overbridge. Khatrapur main station, my lord.
Correct.
My lord, what happened?
East Coast Railway.
My lord, today I have filed the application.
My lord, I am just,
Let us see what he says in the affidavit, sir.
My lord, see the para number 4 and 5, my lord.
Amrit Bharat Station. Tender processing already started.
no, my lord, yesterday I taken the photograph, my lord. Nothing happened.
No, even he says tender process will start, he says. He doesn't know when it will start.
100 years, my lord. They have taken 100 years.
So now it's Amrit Bharat, sir. It's going to be Amrit Bharat.
100 years. My lord may
see. Amrit means 75. That's what, no?
My lord may see the photograph of the railway station, my lord. Naked. Total naked railway station, my lord. That is nothing. Put over is not there. Easter.
No, just.
My lord.
Man, it's all right. He's not saying foot overbridge is there, sir. He's saying they're now thinking as Amrit Bharat Station, it will happen.
My lord, a specific time may be given. Nothing.
He says it taking process in April 23. In para 4 of the affidavit handed over today in court by counsel for the East Coast Railway, it is stated that the work, open quotation, work of foot overbridge, open quotation, will be processed in April 2023 for sanction in umbrella work 2023-24 by Railway Board, unquote. In para 5, it is stated that the Chhatrapur station has been identified for being developed as developed under the single quotes Amrit Bharat Station scheme, unquote, which work would include a 12-meter wide foot overbridge, and that the tender process has already started, and that the work will be commenced, single quotes, shortly, unquote. Full stop. A further affidavit shall be filed by the ECR before the next date, setting out the precise timelines for completion of the work. For commencement and completion of the work of the FOB at Chhatrapur Station. List on.
My lord, I also filed the other affidavit by Railway Board, my lord.
All right, 18 July. Right.
All right.
Item 84.
My lord, pursuant to the last order, we have to file the policy that regarding
State will not, it is the school mass.
Yes.
school mass is also a part of the state.
Yes, I'm aware.
We are also a part.
My lord, they sought 2 weeks time.
Yes.
Your lordship pleases to grant them more than 2.5 months time. Now again, he is asking for time. My lord, may I kindly consider.
Some more time is required.
What is that more time, sir?
He said that their counsel on that date,
3 weeks.
on the last date, they have said that the policy has already been drafted. Yes, 2 weeks, they will take 2 weeks time.
Yes,
now
that is also
more than 3 months time.
For certain reasons, your lordship, not because of that.
Because the assembly is going on now.
What is assembly to do? Best is not.
All the officers are in.
We clearly say no statues for anyone in the assembly.
That is the problem.
Simple policy.
That is the practical problem.
So that's the fact. So your lordship grant 3 weeks more time.
despite adjournments sought and granted on 14 September and 5th January 2023. One more adjournment is sought by Counsel for the State for placing before the court the finalized policy paragraph. As a last chance, list on June 28th.
Oblate.
The policy to positively be placed on record by that date.
Item number 85.
May I please, my lords, I am the video conferencing.
Yes, please.
In item 85, my lord. Here, my lord, I have received the copy of the counter filed by the state, my lord. A detailed count rejoinder is necessary. I will file the affidavit within a period of 1
All right. Rejoinder will be filed for the next date. List on 3rd July, sir.
3rd July. Okay.
Item 86.
86, my lord, last time Lordship has directed the government to submit the document, my lord. My candidature was cancelled. Though I am the resident of the village, the resident certificate was issued by ID Annexure 3.
You have to produce the record of the ADM Puri.
Yes, my lord. I have got the records.
So after a report that is page 36, my lord, joint inquiry. And the resident certificate is 26, my lord, Annexure 3, my lord. 24.
And for the OP6, my lord, the selected candidates, man.
My candidature was cancelled only that the lady she belongs to Brahmin community and he married to a scheduled caste person. That is why he is not a resident of the
Not that.
This is the ground. That is not the order of the ADM.
He was not a permanent resident. He was not the permanent. There is no report. The report is silent about his permanent residence, my lord.
That is the only the ground. That is the page your lordship may kindly see.
No, I think the allegation was that a certain document was not part of the record.
From 2010, I am working till date, my lord.
And the marriage was
at a meager amount of rupees 2,000.
Marriage was solemnized in the year 2008, November, and advertised was in 2012, 9 December. After 1 and 2 months, how the residents at the recitation was made in the marriage certificate will be reflected. And that is also stated that I am belongs to Jagannathpur. That at that time of a marriage, I was residing at Haripur. My residence certificate is not cancelled till now. Nobody has challenged it.
No. It was a residence certificate placed before the authority.
My lord. That was the place. Annexure 3 I have submitted.
No. Was it part of the record of the ADM? That is why I think we called for the record.
Yes,
my lord. I have submitted.
Annexure 3 is your residence certificate, right?
My lord.
Huh?
My lord.
Annexure 3?
My lord.
So is it part of the record? Just take it out. Have you submitted this document earlier? This is the record of the ADM. Show it to him, please. Show it.
Yes, madam. Since some objection raised regarding the status of the residence, my lord, therefore all the records has been objection raised by the petitioners also. That is why the records has been sent to the CDPO, sent all the records to the Tahsildar for status report of the status, my lord. Then after verification, RI has submitted the report, my lord, and Tahsildar also submitted report that that all the, out of 7 applicants, six applicants are outsider, my lord. And regarding the applicants, my lord, the RI reported that she married to a scheduled caste member of the center area, my lord. But silent about his foreign status, my lord. He is not staying there. She was not staying there at the time of process, my lord. That is the report of the
31st December 2009. The certificate is 31st December.
Therefore, all others also filed the residential certificate. They are also they filed also residential certificate, my lord. All 6 members, my lord. That is why CDPO sent all the residential certificate to the Tahsildar for verification and report.
The report said that दरखास्तकारी जाति ब्राह्मण अटंती एवं से हरिजन साहि रे जगन्नाथपुर बारवाटी विवाह कर।
That's it. At the time of process, at the time of selection process, it is mandated that applicants should have been the permanent resident.
Resident certificate is not challenged till today.
That is not.
Neither it is cancelled nor challenged by
that
anybody.
Is for specific purpose. That is not for.
That is the decision. That
certificate
is
for specific purpose.
But what do you do? There is a residential certificate issued by the Tahsildar.
And lastly, CDPO and RI inquiry, that is annexure 9, my lord, page 36. They have stated that 11 years or last 11 years I am residing.
That is the joint inquiry in 2015 after loss of 5 years. Not that period, my lord. Not related to 2010 when the selection process was started.
I am the resident certificate was issued in.
So this is a joint inquiry report that is in the 2015.
And nowhere in the guideline of the Anganwadi worker stated that a marriage certificate is the resident certificate override the resident certificate, and the resident certificate is within 6 months, and the marriage was solemnized prior to 1 and 2 months, 1 year 2 months. How it will be that prove that I am the resident of that area? And RI report is not the overriding effect of the certificate issued by the Tahsildar.
No reply was filed in the writ petition.
No.
Oh, why?
That's after 2 dates that has been disposed of. That's me. This is the order, 4th order. Admitted fact, there is no dispute to Annexure 3 of residential certificate. But only on the basing on that inquiry report, she has not been considered.
Where is the RI report here?
That is page Annexure 7, page 26, man. That is Odia one. Second, my name stands place at second. Dewey. Staying within the Anganwadi area. Below that, second. दरखास्तकारिणी जाति रे ब्राह्मण अटंती से
भल पाई हरिजन साहि
हरिजन साहि रे Barabatri Vibha Kurchan. This is my residence. Barabatri means the Anganwadi center area.
No, the next part. This one.
That is the report.
This is the report. No, this is the report. No, is that the Tahsildar report? RI report, sorry, Revenue Inspector. April 2010 report of the RI shows that you're not staying there. The RI report.
Basing on the RI report, I was issued a caste certificate. Otherwise, caste certificate should not be.
No, residence. We are now on residence, sir.
Residence.
Resident. Residence. Resident certificate is issued.
No, not based on the RI report. Residence certificate is dated 2009.
Tahsildar, unless until the RI report is there, Tahsildar will not issue any residence certificate. This is the year.
So the RI report is subsequent to the Tahsildar certificate.
Subsequent, that is only the ground, but that is stated that I am belongs to Brahmin and married to the Anganwadi center area.
Resident boy. That you are a resident of the Harijans is misleading.
That is the report says that Vibhranta Kul.
Serial
number 2 of annexure 2 hearing. Surface Kari, Jasmine Brahma, importantly, see horizon side, Baravati, Vibhranta Kul.
Vibha Korchand. Then more Rahul English at
Vibha.
Vibha Korchand. Marriage.
Married. We have. Vibha is marriage. Yeah.
I am not residing there. Nowhere it is mentioned. I am married and staying there since my marriage.
Yes, there is no dispute.
So the report is something else, sir.
No,
and joint inquiry also.
Just a minute. Report is RI reported that she is married to a person who is married a person of horizon side. Married a person of origin side, but at the time of marriage, she was somewhere else. It's outside of the center area, but a report does not say about his foreign status is the Baravati man.
No,
report does not say about his foreign status, foreign residence.
So which means you can't discount.
Report is silent about his residence.
Silent, then you can't discount the residency certificate that has been issued. The residence certificate actually says she resides in the horizon side.
Jagannathpur Pada Baravati side.
Baravati side. That's the center area.
That is, all others also applied.
There is nothing to the contrary then. There is nothing to the contrary in the RI report.
RI report does not say that she's staying in the.
But look at the impugned order. The impugned order proceeds on the basis that the RI report has said she is not staying. Just come to the impugned order. Page 40. RI has conducted an inquiry and found that the petitioner is residing in Haripur. There's nothing like that. There must be a basis for that.
RI has conducted an inquiry and found that the petitioner is residing in Haripur.
Where is that? You show us from the record. Where did this RI report say that?
And not in Jagannathpur.
Show us from
Jagannathpur where the Anganwadi center is situated.
Show us that RI found out. Show us that the RI's report says this.
No, RI report doesn't say that.
You just now read the statement of the single judge that the RI report says she stays in Haripur.
He is ever silent, my lord.
Then the whole basis is wrong. The entire basis is wrong.
This is the only, but does not, it is silent about his status.
So then which means the residential certificate clearly shows she's staying in the, yeah.
But,
you see, the challenge in the present writ appeal is to an order dated 7th October 2015 passed by the learned single judge dismissing writ petition civil 7. Who is now working there in the center?
I am working there, my lord. 13 years have already been passed now. 12 years some months. And she must have been engaged somewhere else.
No. I am not. I am fighting from pillar to post.
And now I have the
justice.
Over-aged, my lord. I cannot be
aged.
Over-aged, I cannot get any other employment there.
Against an order dated 7th October 2015 passed by the learned single judge dismissing writ petition civil 7107 of 2013 filed with the present appellant, thereby affirming an order dated 12th December 2012 passed by the Additional District Magistrate Puri (ADM), dismissing the appellant's Anganwadi worker appeal number 58 of 2010. Paragraph. The background facts are that an advertisement was published on 21st December 2009 for appointment of an Anganwadi worker (AWW) in respect of the 81 Anganwadi centers. The appellant applied for appointment at the Barabati Anganwadi Center of Jagannathpur Gram Panchayat (GP) under Pipli Block, District Puri. The Moza for the said AWC was the villages Hamlate, Kumhar, Sahi, and Barabati. The appellant and including the appellant, 7 candidates applied for the post of AWW at the Barabati AWC. Barabati Additional AWC. Appellant, along with their application, produced a residential certificate issued by the Tahsildar Pipli, dated 31st December 2009, showing her to be a resident of village Jagannathpur, Barabati Sahi, PSP Fleet. According to the appellant, after her marriage to one Abhimanyu Behra on 10th November 2008. She has been residing at the village of her husband, that is Jagannathpur, Baravati Sahib. Paragraph. According to the appellant, although she satisfied all the requirements and had secured the highest mark among the applicant candidates, respondent number 6 was appointed as the AWW. Full stop. The challenge to the selection of respondent number 6 by the appellant by filing writ petition civil 20142 of 2010. No, you see the appellant challenged the selection of respondent 6 by filing writ petition civil 20142 of 2010 in this court, which was disposed of on 21/12/2010, permitting the appellant to file an appeal before the ADM. So the said appeal AWA 58 of 2010 was dismissed on 12/12/2012, stating therein that the residential status of the appellant as well as the respondent was inquired into by the local Tahsildar. And it was reported that the appellant, being a Brahmin, got married in the Harijan Sahib, Baravati. And there was no report of her residing at the Harijan Sahib. So on the ground that she was not staying in the AWC area, but at Haripur, as indicated in the marriage certificate, the appeal was dismissed. Paragraph. Contending that her residential certificate was valid and had never been challenged or cancelled, the appellant challenged the aforementioned order of the ADM by filing writ petition civil 7107 of 2013. Stop. The additional basis for this no 2013. Full stop. However, the said writ petition was dismissed by the impugned order dated 7/10/2015 by the single judge, which proceeded on the basis that the inquiry conducted by the revenue inspector (RI) showed the appellant to be a resident of Haripur and not Baravati Sahib, and not Pada Baravati Sahib. Paragraph. This court has produced the original record of the ADM as produced for this as original record of the ADM to dismiss the appeal of the appellant. It has also heard the submissions of learned counsel for the appellant, respondent number 6, and the state. Paragraph. The Child Development Project Officer, Pipli, made a submission dated 23rd July 2011 to the ADM in the aforementioned appeal, stating that when the residential certificate submitted by the appellant was sent for verification, the verification report open quotation, did not categorically state about the residential status of the appellant Madhusmita Das, unquote. Only because the report was not clear, the selection committee, open quotation, considered her as outsider in the Anganwadi Center area in its meeting dated 23rd September 2010. Paragraph. This court has perused the report submitted by the revenue inspector on, what's the date? 20th April 2010. Full stop. The report only talks about the appellant having married a person belonging to the scheduled caste, but does not state anything whatsoever about her not residing in the AWC area. Full stop. Paragraph. It is therefore not understood how the ADM could conclude that the report of the RI showed that she is a resident of Haripur and not Pada Barabati Sahib. Full stop. If the report of the RI was silent on her residential status, then the ADM ought to have proceeded on the basis of the residential certificate issued by the Tahsildar, clearly stating that she is a resident of Pada Barabati Sahib, which is in the AWC area. Full stop. That certificate, dated 31st December 2009, has not been cancelled or held to be invalid for any reason whatsoever. Paragraph. Consequently, the very basis on which the ADM has proceeded and which has been concurred with by the learned single judge
Your Lordship,
is shown to be non-existent. Full stop. In other words, there is nothing on record to show that the appellant at any point in time after making of the application for the post of AWW ceased to be a resident of Barabati Sahib. Full stop. In that view of the matter, the impugned orders of the learned single judge and the ADM are unsustainable in law and are hereby set aside. Paragraph. The court is informed that Respondent number 6 has been working continuously for over 13 years now. Full stop. In view of the order passed today, the opposite party state is directed to issue orders disengaging Respondent number 6 and engaging the appellant as AWW in the concerned AWC. The said order be issued within a period of 4 weeks from today. The writ appeal is allowed in the above terms.
My Lord,
no orders is to pass.
I may be permitted, my Lord. ADM has stated that in marriage certificate, both are staying at Haripur, my Lord.
So marriage certificate does not indicate the residential status. Right. Yeah, the record is returned to counsel for the state.
Item number 87.
87 Millers. 87 Millers. The matter may come along with the petition for substitution filed today.
All right. Counsel for the appellant states that he has today filed the application for substitution. List on.
Let the interim order dated 23/4/2018 may be permitted to be continued.
All right. 16th May. Interim order to continue.
88.
May I please, ma'am? The appellant before your lordship is drawing your lordship's attention to the order passed by the Honorable Single Judge, my lord, under Annexure 1, my lord,
as well as the order under Annexure 2. The humble submission of the appellant before your lordship, the order under Annexure 1 is not having any link with the order under Annexure 2, my lord. That is separate case, and receive and under order under Annexure 2 is also separate case, my lord. On the basis of the submission made by the petitioner therein before the Honorable Single Judge, the order was filed, my lord. Fact remains, my lord, the petitioner before the Honorable Single Judge has filed the writ petitioner challenging the Annexure 7 of the writ petition, my lord. Annexure 7 of the writ petition is at page.
So by now the impugned order must have been complied with.
My lord?
The impugned order must have been complied with, sir.
So far as my instruction is concerned,
there is no stay of the impugned order.
No stay of the impugned order.
So it has to be complied with by now.
State may answer, my lord.
Yes, sir. Actually, the opposite party number 6 in the writ petition is one Jatin Kumar Das.
My writ petition is.
The other one.
Other one.
6520.
6520.
But anyway, the only order is that the collector should hear again.
My lord, that is the important issue, my lord. May I draw your lordship's kind attention to the paragraph, to the Annexure 7 of the writ petition filed by.
Why is it not implemented? 1 minute, sir. Why is this order not implemented yet? Yes, passed on 10/1/2019.
My lord.
And how are you agreed? If it's only a fresh hearing.
My lord, just subject to your lordship's permission, may I draw your lordship's kind attention to page 20, Annexure 7 of the writ petition, 6520, my lord.
Right.
Page 20. That is under challenge before the Honorable Single Judge, my lord. That is the order, not the representation. The earlier, the order which was referred to in the present writ petition is the representation. It is the order. Your lordship may kind enough to visualize, my lord. Selection as GRS in Dhamnagar block under Dhamnagar GP, my lord. I am to inform you that the collector Bhadrak has been pleased to select you as GRS for Dhamnagar GP under Dhamnagar block. You are therefore directed to contact with the Sarpanch with all required documents for engagement as GRS under the intimation to this office. And I am also continuing on the basis of this, my lord. This is the order. They have challenged Annexure 7, my lord.
Correct. But earlier, their representation was asked to be disposed of by the collector. This is the second round they have come before the single judge, sir.
My lord.
In the first round, their representation was asked to be disposed of by the collector.
Yes, ma'am.
Since the collector passed an order without giving reasons, they had to file a second writ petition.
My lord, that is a reply of the DRDA in this appeal, my lord. May I draw your lordship's kind notice the reply filed by the DRDA in WA 47, my lord. Annexure B/3, my lord. Annexure page 6, my lord.
Correct.
Page 6 of the reply filed by the DRDA. Annexure A/3, my lord. That is the order of the collector dated 14/3/2008, my lord. May I read, my lord? That is the entire order, my lord. Page 6, if your lordship would allow me to submit, my lord. Page 6, my lord. After hearing the petitioner is the present on that writ petitioner, my lord, and other parties, and verification of record, it is revealed that Srimati Star Rani Panda was selected to engage as GRS in Dhamnagar GP with a direction to.
This is the original order, sir.
My lord.
I think you're not following what the single judge is saying. This is why you are arguing like this in circles. This is the original order on the basis of which you got appointed.
My lord.
This is the 29th March order on the basis of which on 8th April you were appointed.
My lord.
Your appointment has been challenged.
My lord.
In that challenge, they've asked the representation to be considered by the collector.
My lord.
That collector has not passed a reasoned order and rejecting the representation. That is why he has challenged it again.
I think it is a reasoned order subject to your lordship's.
Where is that order? You show me which is the reasoned order, not this 29th March. 29th March is the original order prior to your appointment, sir.
Yes. Yes.
Suddenly it's not.
Withdrawing my loan. Withdrawing my loan application, my lord. I can understand, my lord.
All right.
I am for OP number 6.
The impugned order on single judge merely requires the collector, Bhadrak, to consider the representation of the petitioner. That is respondent number 6 herein. And after giving a hearing, to pass a reasoned order. Regarding the prayer of respondent number 6, questioning the engagement of the present applicant as multi-purpose assistant (GRS) in the Damnagar Gram Panchayat. Paragraph. Since the impugned order merely requires the collector to pass a fresh order after affording an opportunity of hearing to the parties, the court sees no prejudice being caused to the present appellant whatsoever. There is no merit in the present writ appeal. It is dismissed as such.
Item number 89.
89. For acute illness, I pray for 2-3 weeks after.
2020 matters. Tell us what it is about.
20. It is about regularization of the petitioner. It has been regularized, and one of the writ petitions was posted to 29th August. And the dismissal on the ground is not tenable. But since I am acute illness, kindly allow me.
What's wrong with the impugned order? It's been dismissed for non-jointer of parties. That's all. Nothing wrong with the impugned order, sir.
No, the second one that is there. Vice Chancellor is there, but so far as so many workers are there, it cannot be. It is not possible. Only constitutional courts can examine them. And the third ground is that I have been regularized in the meantime, but I have challenged the very process. That process will not exist. But I did not took a stay order also. It was division matter. Division bench was agreeing to give me, but I said it is a matter of regularization. It is not an employment, recruitment, or advertisement. So okay, I am now in a place, my lord. Names may be affected.
No, let's go one by one. Writ Appeal 336 of 2022 challenges an order dated 16/12.
Yes, my lord.
So that we are rejecting, saying it's only because you did not implead everybody's parties, it was rejected.
No, my lord, you see, at the time of filing, only I challenged the notification. That was a division matter, and division matter was giving me stay. But in regularization, why should I seek stay? Stay if it is a public employment, advertisement, or employment, then only. And the single bench could not distinguish and said to implead everything at the last moment. Your lordship will decide all on the basis of only notification, whether it is a for regularization or not. Only I pray, give me 2 weeks time, I will be ready.
2 weeks time for what?
I am acute diabetes with one leg has been swollen and the sore has been taken place. I am unable to move anywhere, my lord.
All right. Counsel for the appellant stated to be unwell. List on. 28th August.
Item number 90.
Item 90, my lord, he has appeared. That's his outsourcing matter, your lordship, that's special list matter. That
When
can
are
be.
listed?
My lord, I am appearing
8th
for the.
August.
My lord, I am appearing for the opposite party. A
Yes, I am
copy of-
saying that. You have appeared, I am saying that.
8th August, sir. All right. Over. All right. After lunch, we'll.
Supplemental list, fresh admission, item number 1.
Item 1, Your Lordship. Prayer for quashing of the proceeding. Last order, Your Lordship kindly sees. The Honorable Court has asked for instructions with regard to the stage of the trial and availability of that particular cast file. Because in absence of the cast file, my name has been included, and that too after 13 years of the occurrence. I have already been retired from service. I have already been retired, Your Lordship. Unnecessarily, a case is being hanging like a Damocles sword since 2013, Your Lordship, for no fault of mine. Merely because at that relevant time, I was the RI of the concerned circle, so my name was there. Issuance of fake certificate and in view of the...
No, but there was no stay granted by this court. No stay has been granted.
No, there is no stay.
Stay, as far as my instruction, Your Lordship, the other accused persons was challenged. That report has been stayed. My Lord,
which accused? Why are all the matters not tagged together? Which accused was challenged? Why? Where? What are those petition numbers? Give us. Give me the numbers.
Other numbers. Other numbers. That's actually right now I don't have.
Then it's okay. You say permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
Item number 2.
My Lord, in the meantime, the final form has already been submitted, stating therein that the case is false one.
So
kindly see page 9. Kindly see page 9.
So you withdraw this. You withdraw this then. You withdraw. So you say
page 9. Last paragraph. During investigation and supervision,
this affidavit is of
it is
September.
ascertained.
This affidavit is September 22. You just kept it with you.
Final form has already been submitted.
I don't know.
Affidavit.
The mic is not working, is it?
Affidavit I have filed.
Mic is working.
Yes.
Yes.
I'm asking something else. You're saying something else.
Affidavit has been filed.
No.
Affidavit September master.
September master the affidavit has been sworn in the month of September because a connected matter was there. I have filed the
No, here the habit is keep the affidavit in your hand. Don't file it.
No, my Lord, that is my mistake. Because another matter was there connected. That affidavit has been filed.
Anyway, now you withdraw this. It's an affidavit dated 20th September 2022 has been handed over in court today, stating that a final form dated 14/9/2017 has been filed in the FIR in question, stating that no case is made out. That view of the matter, nothing survives in the present petition. It's disposed of as such.
Well, the proceeding may be quashed.
Now you know, sir. Why should we quash? The court there will close it.
Item number 3.
My Lord, on behalf of Mr. Samarendra Mahatin, no instruction, my Lord.
No instructions dismissed.
Item number 4.
Not pressed, dismissed.
Item number 5.
None of is dismissed.
Item number 6.
None of is dismissed.
Item 7.
None of is dismissed.
Item number 8.
Same order.
Item number 9.
Same order.
Item number 10.
Same order.
Item 11.
11 are appearing for the OP, my Lord.
None appears for the petitioner. He appears for the respondent.
Mr. Yuvarjana.
Item 12.
May I please, Your Lords? Here, a civil proceeding, purely civil case of way back of 2012, given a color of criminal texture, my Lord. What happened? A company of Uttar Pradesh purchased certain property from Sundargarh district for the Jatroba plantation.
You've not even implemented the
Till date, I have not been implemented as a party. I mean, I am not an accused there in the prosecution's case. The affair was registered against some of the company persons. I'm one of the directors. First one is a case where director is the party who was not the signatory of the document. Cell deed in question is under challenge.
You have not implemented the informant as a opposite party, sir.
Because in the meantime, investigation charge sheet, prosecution is taken by the crime branch and submitted the charge sheet without implicating me as an accused.
Then,
if cause of action survives, I will
counsel the petitioner seeks
I'm sorry, my lords, item 11, my lords, I missed out. My lords.
Yeah, tell us.
My lords, here there is some development in the windmill. If your lordship will kindly give me 2 weeks time or 1 week time, my lords, I'll get some. I'll come back, my lords. Some development, my lords, regarding compounding. So therefore, my lords, your lordship,
that all you can pursue there, sir. No problem.
No, my lords. What I'm submitting with all
there's anyway no stay. There's anyway no stay.
My lords, here the matter is a very meritorious matter, my lords. So therefore, your lordship, this matter may lie over for one chance, my lords, just one chance. I'm not praying for any further, my lords, just one chance.
No, there is no stay. Matter. So the matter must have gone on there, please.
Yes, my lords. That is what just ascertain.
You can file a fresh petition whenever cause of action survives.
If your lordship will just grant one small one short adjournment, my lords, I'll come back to your lordship. Lordship, just 10 days time, lords.
No. You see, permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
I don't know, 13.
Very great.
None appears dismissed.
So the MC, but the dispose of case. MC.
MC is dismissed. Yeah, none appears dismissed.
Item 14.
Madam, my lord, I'm on VC, my lord. My lord, a settlement has already been arrived between the parties, my lord.
Where is that document?
My lord, may allow some time, my lord.
Which party, sir?
My lord, there is a dispute between the conducting lawyer in a civil suit and the defendant, my lord.
You place it before the trial court, sir. Permitting the petitioner to raise. It is stated that the matter has been settled between the parties. It will be open to the petitioner to place it before the trial court and seek appropriate orders. The petition is disposed. Interim order is vacated.
Item 15.
May I please, your lordship? My lord, here the petition also challenged the impugn order under Annexure 2, my lord. Order dated 24/10/2011, passed by the learned JMFC Visham Katak, framing charge under section 498A, 494, 328, 506, 34 of IPC. There is stay, my lord. There is stay order. But in pursuance to order dated, my lord, 1/8/2022.
494 means what? Bigamy?
Bigamy. 494.
Bigamy.
Uh-huh.
My lord. The newly added informant notice has to go to the newly added informant, my lord, or as opposite party number 2, my lord.
What is there in the matter? Tell us.
There is nothing, my lord. The petitioner number 1 married to the informant's daughter prior to 7 years, my lord. It is the case of the prosecution. That prior to 7 years, my lord, the enforcement.
Divorce proceedings are still pending.
Yes, it is pending, my lord.
Then
because no case is made out so far as the petitioners are concerned, my lord.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. Interim order is vacated. Right.
Item number 16.
May I please, your lord?
Yes.
I have filed this application of quashing of the inter-proceeding on the ground of compromise. Compromise at flag 1.
Flag.
Yes.
Accept flag of informant. All right. Counsel for the informant agrees that the parties have settled the disputes as indicated in flag 1. Flag A or flag 1?
Flag 1.
Yes, flag 1.
Oh, 17.
Item 16.
17.
Sorry.
17.
16. Okay, none appeals. Dismissal non prosecution. 17.
16 both the cases.
17 is my matter. That
17 you
one
say
that is there.
Counsel for the informant agrees that the parties have settled their disputes. This affidavit is on record. In that view of the matter, takes the prayer clause and all proceedings considered that are hereby quashed.
Obliged.
Item number 18.
None appeals dismissed.
Item number 19.
May I please, your lordship? My lord, on behalf of Mr. R. Achari, my lord, the present petitioner has challenged the cognizance order dated 26/7/2014, my lord. My lord, I pray liberty may be granted to
permitting the petitioner to raise all pleas. Here, properties.
Grateful, my lord. Grateful.
Item 20.
Yeah, PC on top.
May I please, Your Lordship, permit to raise all the points code.
Permitting the petition to raise all please.
Objection.
Item 21,
None appears dismissed.
item 22,
Same order.
item number 23,
Raise all the point after.
Permitting the petitioner to raise all please. Your proposition.
item number 24,
Memo taken and record dismissed as withdrawn.
item number 25,
None appears dismissed.
item number 26,
26 May, please. The compromise has been made between the parties, my lordship. Flag A, my lordship, the compromise affidavit has been filed, my lordship. Case arising the matrimonial dispute between the husband and wife, my lordship.
All right. Divorce is already granted.
Compromise has been made between
No, no, but
parties.
what about?
My lordship.
No, no. Has divorce been granted?
Divorce that some alimony has been.
All right. You see, the affidavit of opposite party number 2, stating that she has arrived at a compromise with the petitioner and has received payment pursuant thereto, is on record. This is not disputed by anyone. Consequently, GR case take that from the prayer clause and all proceedings consequent thereto are hereby quashed.
Obliged.
item number 27,
And I am for the petitioner. I am in virtual mode, my lord. Lord,
Yes.
here the prayer is to quash annexure 4, which is a summon issued under section 250 of CRPC by the judicial magistrate to the chairman cum managing director of Gridco to pay compensation to opposite party number 2. My lord, the facts are like this. My lord, OP number 2, my lord, it was found that she is diverting some electricity from his domestic line to commercial line. Then, my lord, the assistant engineer of Gridco with his squad visited the spot, submitted a report against her. Then the judicial magistrate electricity, my lord, took cognizance, registered a case and tried the matter. Ultimately, he acquitted the lady, OP number 2, on a finding that there is no sanction obtained and also there is no proper ground to proceed against her. But while doing that, in paragraph 9 of the judgment, what he did, he issued summons to the complainant as well as to the managing director of Gridco to show cause why they shall not pay compensation. To the complainant, it is okay. It is available in section 250 of CRPC. Who is the complainant? Who is present in
That's
court?
right. The company is the complainant.
Here the assistant engineer
Right.
filed
Yes.
the case.
Yes.
And finding is there was no sanction. If
Correct.
there was no sanction by the by Gridco, then
Right.
the managing director had no knowledge of this.
Correct.
So what I pray, I am not praying for passing the judgment. I am only praying that portion of the summons which is issued to the managing director to show cause as to why he shall not pay compensation. She is acquitted, it's okay. We have nothing to say. Only prayer is to quash annexure 4.
All right. The challenge in the present petition is to a limited extent, is to the order passed by the JMFC bracket mobile electricity Bhubaneswar on 3rd July 1998 in 2C case number 602 of 1995, only to the extent that while acquitting the opposite party number 2 of the offense under section 41 of the Indian Electricity Act on the ground of non-obtaining of sanction by the complainant, namely the assistant engineer bracket electrical, Gridco, the trial court has proceeded to issue summons to the present petitioner in his capacity as chairman of Gridco as to why compensation should not be paid to the opposite party number 2. By invoking section 250 of the Code of Criminal Procedure 1973 paragraph. Despite opposite party number 2 having been served and earlier counsel appearing on our behalf, today none appears. This court has heard the submissions of Mr. Panagar, senior counsel, appearing for the petitioner. Paragraph. The requirement for obtaining sanction under section 41 of the Indian Electricity Act 1910 is the responsibility.
Well, sanction is section 50.
Yeah.
Section 50.
Yeah, 50 of the IE Act is of the complainant. That is the original complainant, that is the Orissa State Electricity Board, bracket OSEB, which conducted the raid in the premises of opposite party number 2. Gridco came into the picture only later with the reorganization of electricity companies in the state. Full stop. Under section 250 of CRPC, it is open to be magistrate, while discharging or acquitting an accused, to call upon him, open quotation, person upon whose complaint or information the accusation was made, unquote, to show cause why he should not pay compensation to the accused. Paragraph. In the present case, indisputably, the complainant was Gridco, which stepped into the shoes of OSEB, the assistant engineer of which conducted the raid. Stop. In fact, it is the assistant engineer bracket electrical who actually filed the complaint on behalf of OSEB. Stop. By no stretch of imagination could the managing director of Gridco be made liable in terms of section 250 CRPC for the purposes of payment of compensation to opposite party number 2, consequent upon her acquittal. Paragraph. Clarifying that such a liability, if at all, would attach to the corporation, that is Gridco. The court sets aside the impugned direction issued in the judgment dated 3rd July 1998 of the GMFC bracket Mobile Electricity Bhubaneswar, insofar as it seeks to summon the present petitioner under section 250 CRPC. The petition is disposed of in the above terms.
Item number 28.
I may be permitted to withdraw my
dismissed as withdrawn.
Item number 29.
None appears dismissed.
Item number 30.
None appears dismissed.
Item 31.
None appears dismissed.
Item number 32.
None appears dismissed.
33.
Same order.
34.
Same order.
Item 35.
35, Lordship, liberty may be given to raise all the points.
Permitting the petitioner, please.
Grateful, Lordship.
Item 36.
Lord, item 36 and 67 may be permitted to raise all questions in the appropriate stage.
All right.
36 and 67, madam.
Both. All right. All right.
Item number 37.
None appears dismissed.
Item 38.
None appears dismissed.
Item number 39.
39 may, please, Your Lordship. Your Honor, challenging the order of cognizance
under Annexure 3, Annexure 5, my lord. But at the same time, FR has been lodged and it has been registered and action has been taken on the same point. It is under 498 and final form has been submitted. After submission of the final form, once again one CC case has been initiated and they have taken the cognizance on this one, which is at page 45. On same ground. 498, 323, 34, my lord.
You've not made the informant the party. You've not made OCHA. Who's appearing for the opposite party? Not served. Has the opposite party been served?
No one has entered appearance, my lord.
Then on-shore has excused.
Refused. Refuses deemed service. The notice to the opposite party. Did you implead the state? You would implead the state. What happened?
State is also not included.
Last time you took time to implead the state.
The party was read that he has been as the opposite party.
Anyway, you're there. I don't know. Now the cost title says state of Odisha.
I'll serve the copy in course of the day before this.
All right. Just make sure the cost title is correctly reflected. It's
so far the state is concerned, I have solved the copy, my lord. I have got the receipt.
No, you serve the copy. You have to make them a party. All right. On their oral request of counsel for the petitioner, the state of Odisha is impleaded as opposite party number 2. Copy of the petition has already been served on the counsel for the state. Paragraph. Despite the report of service on opposite party number 1 informant is that she refused to receive the notice. The service is deemed to be complete on her. The contention in the present petition is that after the final report was filed in FIR number
291 of 70.
Yeah. 291 of 2017 in PS Jajpur instituted that the instance of opposite party number 1 under section 498A 323 506 read with 34 IPC and section 4 of the Dowry Prohibition Act 1961. And that was also accepted by the magistrate by the order dated by the SDJM Jajpur. Where is that order accepting the closure report?
My lord, it is at page 45. The cognizance order.
No.
The final form, my lord, page 25. Annexure 3.
My lord, only against husband charge sheet was submitted. So far as others are concerned, no charge sheet was. That is why she filed the second complaint petition.
No. The first case was only against the husband.
My lord, FIR is against 11 persons. All these persons, those who have been added as a party in the complaint case.
I see.
It is at page 20, my lord.
FIR was against 11 persons, charge sheet was filed against only 1.
No. There's no charge sheet, sir.
Final form.
This is final.
Yes.
Final forms. Where is that? Which is that?
Deleting other co-accused persons. Page 37. In the complaint petition, he has made such a declaration.
No. Where is that order accepting the final form?
But it's at 25, but Annexure 3, my lord. Page 25.
No, that's the final form. Where is the order of the court? There must be an order, no?
My lord, page 34.
No, sir.
Yes, sir. 29th January 2018.
No, that is issuing. Cognizance is taken and notice is issued.
In the same set of GR case, my lord. This is the RI.
What are you saying, sir? If there is a closure report, there must be an order accepting the closure report. Where is that order?
Then the informant could have filed petition for protest petition within 30 days. That
Correct.
is. My lord, may kindly see page 35. Page 35. 1cc case number 7. Protest to
Annexure
GR
4.
case number ete pending before this. This is in form of protest. Yes, my lord. This is in form
Raise
of
all
protest.
please at the appropriate stage.
But although this has been once again taken cognizance by the self-same persons.
Yes. Even if final form is submitted by police against those,
They can.
the magistrate can.
So it's the same case. It's not a separate
Same case. Same
case. In
then you say
two
just
separate
take out
forms.
all that. Just say that the oral request is stated simply as a party. No copy of the petition has already been served on him. Say permitting the petitioner to raise all pleas at the appropriate state petitions. All right.
All right. Item number 40.
None of this dismissed.
41.
Same order.
Item 42.
Memo taken on record. Dismiss is withdrawn.
Item number 43.
Not pressed.
Not pressed, dismissed.
Item 44.
44, my lord, questioning of criminal proceeding on the ground of compromise, my lord. Compromise petition, active
right.
flag.
The affidavit
K.
of opposite party number 2 stating that the disputes between the parties have been compromised is on record. Consequently, put from a period clause and all proceedings consequent that way hereby quashed.
Item 45.
None appeals dismissed.
Item number 46.
Not pressed, Lords.
Not pressed.
46, 47.
44 million. On behalf of Mr. Naik Miller, Dharmendra Naik, I kindly taken up next week, taking oath today.
44.
44.
No, he's just 44 compromise affidavit. You don't
48,
even have the paper book. What are you mentioning?
Sorry. 48.
So first of all, if you don't have paper book, don't mention. Yes.
47.
46 and 47.
Both not pressed. Dismissed.
Item 48.
Where is your paper book, sir? I'm not listening to any submission without paper book. Don't read the court like this. Yes.
Well, 48 million. That's why pray, Lord, any day, Lord.
Sir, don't mention without bringing paper book. Do you show us the paper book of this case?
File. Paper book means file ka kind. Ani na.
Where is the file of this case, sir? In your hand, where is the file? Is it this case?
Miller.
Or some other case?
No, this case, Miller.
You have filed a wakalat here.
Miller, I have sub item, Miller.
Who's in the first item?
My 4-5 minutes.
First item, who's there, please?
There is one of the item where actually I also appear. Item serial number 3, I think. Ghanshyam Linker. So there are about 68 accused persons.
What's the matter about?
In 1990, the FIR was given. But this ARC Chaudhar, that the airport matter, where the land acquisition proceeding was there. In different capacities, those persons are there, including lawyers even. So they say, as if the person whose name the land stands was the ex-intermediary, who actually, after getting the Ikpadia and the tenant laser, he claimed compensation because he was the owner of the land. Compensation, a part of it was paid and part of it has not been paid. During that time, allegations was made that he is not the actual owner and he was not the ex-landlord, and therefore the question of hasting doesn't arise. And here the land belongs to the state.
No, has charge sheet been filed or not filed?
The charge sheet has been filed.
No order framing charges is yet been passed.
But in fact, it has not been complete, it has come. But 9 cases out of 14, the charge sheet has been quashed by this Honorable Court, my lord.
Right.
Those judgments are there that will file it. All are in the same footing. Well, there is no tampering of evidence, no nothing.
Show us those judgments.
Kindly see those judgments.
Show the judgments.
But Tahsildar has been acquitted. Now, I am appearing for one of the additional Tahsildar. And the land acquisition officer has been acquitted. But those are all charges has been set aside. I am giving the judgment for it.
Let's go step by step. 290, who's appearing? Who's appearing in CLMC 290? 290. Please call out.
Kindly see
CLMC 290 of 2005.
290.
Anyone appearing in 290? Correct. None appears, dismissed. 1258.
1258, Mr.
1 minute. You are in 1258. 1620. That is yours.
1620.
Let's take it up.
1620 of 2009.
Yes, the judgment's copy are given.
No, but you have chosen to come in 2009.
But one with Jamil Ahmad Khan, he was the Tahsildar Marat.
Lord, it is one of the sensitive issue of.
No, I'm just wondering, why did you file it in 2009?
But after the cognizance was made.
It's all right. So now you can point out to that court at the stage of charge, you can point out this judgment and get out.
Yes.
You say permitting the petitioner. You say at the outset, Mr. S.P. Mishra, that senior counsel, the petitioner points out that.
Can you look at the impugned order?
At the relevant time, the petitioner was the additional Tahsildar.
He was the additional Tahsildar.
That's right. And that others placed in a similar position, including one of the Tahsildars, have succeeded in this court in getting the charge sheet as far as they are concerned quashed. Full stop. He refers to the judgment dated judgment in State of Orissa versus Raj Kishore Chaudhary, 1998, 15 OCR 103. Full stop. The petitioner can certainly place reliance on the said judgment at the stage of charge, permitting the petitioner to raise all pleas, including the above plea, before the trial court of the appropriate state the petitioner is disposed of. The interim order is vacated. Yes.
Then 1258.
Yeah. CLNC 3502 of 2010.
3502 and 3503, same, similar. And there's an order that the principal co-accused has been acquitted.
Counsel, the petitioner here points out that the principal co-accused has already been acquitted by the trial court. It will be open to the petitioner to point this fact out to the trial court.
Judgment to that.
At the appropriate stage, permitting the petitioner to do so, the petitioner is disposed of. The interim order is vacated.
Here only question is the petitioner was a minor.
Whatever, it's all right.
Only a minor. He just received that amount.
All right.
And he had not laid any claim before the compulsion.
All the pleas you can raise there. Now come to 1258.
3502 and 3503.
Same. My lord, they poor arrive, lords, who arrive. Others are of the quast Tahsildar, additional Tahsildar.
Same. All right. Same. So you say, counsel, the petitioner states that other co-accused placed in similar footing have either been discharged or acquitted by separate orders, either of this court or of the trial court itself, permitting the petitioner to raise all these pleas, including any other pleas in accordance with law before the trial
charge
court.
Has been quashed. Acquittal is not. Charge has been quashed in all cases.
The charge sheet has been quashed.
Yes. And in my case also, they have filed affidavit by the crime branch saying that there is a civil dispute also pending.
All right.
That is for recovery of the I have filed all those cases.
All right.
Lord, I'm the petitioner in the criminal misdemeanor number 290 up to 2005, my lord. I'm just a clerk, my lord, in the land acquisition.
Another 1552.
And my duty is to place the file before the land acquisition.
Correct. We don't get into the details of that. Same order in 290 also. Right.
Is it 490?
Right.
Item number 49.
My lord, 1552, there is another Punjabi Kishore Das, Rajkishore Das.
Where is that?
1552, criminal miscase.
All disposed of cases, it says.
52. That is yours.
I think it's all disposed of. All disposed of cases.
Yes, my lord.
They're all disposed of. Right.
Item 49.
None appears dismissed.
Item number 50.
Liberty, my lord. Liberty may be allowed to raise all this point.
50 Liberty. Yeah.
Item 51.
None appears dismissed. Both matters.
Item 52.
May I please, my lord? Cross of this case is this. The prosecution has not filed any petition under section 311 CRPC. The learned CGM by his somewhat the case was posted. My lord, kindly have a glance to order dated 24/5/2011. Page 6, my lord. The case is posted to today for judgment. On the same day, the learned CGM is next page, my page 7. Therefore, it is necessary to summon the present MD of Nagapur MP for his examination as a court witness. Therefore, judgment is deferred. The prosecution case is reopened. Issue summons to the MD of Noaga and Lamb with a direction to produce the documents relating to the appointment of the accused person and entrustment of their duties during the period of audit, fixing the case to 3611 for hearing. I have given a judgment, my lord, of this annual code, my lord. My lord, kindly have a glance to para 6, 2005-31 OCR, my lord.
So without any application moved?
My lord, I may pardon.
No application was filed for this.
No application. The court has so much passed this order. 2005-31 OCR, page 726, paragraph.
All right.
6.
The challenge of the present petition is from order dated 24th May 2011, passed by the additional CGM Rourkela in GR case number 1468 of 2000, which reads as under. Reproduce the whole order. Paragraph. Relying on the judgment of this court in Bimal Krishna Tripathi, State of Orissa, 2005-31 OCR 726, it is submitted that the impugned order was not preceded by any application moved by the prosecution, and there was no occasion for the court to suo motu summon the present petitioner only because he required to examine the documents pertaining to the appointment of the accused persons. The impugned order, to the extent it summons the present petitioner, is hereby quashed. The petition is allowed in the above terms.
Item number 53.
None appears to be petitions.
Item 54.
54, my lord. This matter was filed in 2013. In the meantime, my lord, in 2022, one application of 239 CRPC was placed before the special judge. It was disposed of, and I want to raise better points with liberty to assail on better.
Correct.
Before this,
in view of the subsequent developments, counsel for the petitioner seeks leave to withdraw the present petition with liberty to raise all points at the appropriate stage in the trial court. The post of is withdrawn with liberty spread.
Item number 55.
The documents, original documents and certified copies.
Correct. Original documents / certified copies be returned to the petitioner, subject to being substituted with attested photocopies.
55.
Well, quashing of the criminal proceeding on the ground, it is a proceeding under 138 on the ground that the company is not arraigned as a party. And
all right, both these petitions are.
But I may pardon, I am appearing for the informant, complainant. I will kindly have a glance to page 8 of the order. The accused persons has admitted and
doesn't mean it is a criminal case. Question of law, sir.
Madam, I permitted to impute the company.
That you have to pray in the trial court, sir, please. And there's no provision for amending complaint at all. There's nothing like that in the CRPC. You see, both the present petitioners have been arraigned as accused only because they were directors of a company which issued the check in question. However, the company itself, that is Sarla Realcon Private Limited, has not been made arraigned as an accused. Paragraph. On the basis of the legal position explained by the Supreme Court in Anita Hada versus Godfather Tours and Travels.
AIR 2012 Supreme Court.
Once you see case number 41 of 2014, and all proceedings consequent thereto, as far as the present two petitioners are concerned, I hereby quashed.
Both the cases. AIR 2012 Supreme Court 2795.
All right.
Item number 56.
56, my lord, liberty may be given to raise all the
permitting the petitioner to raise all these.
Item 57.
57, senior constable Mr. Sarangi is ill, my lord.
What's the matter about, sir? Tell us.
Well, she severely fever has come yesterday.
What is the matter about? Tell us, sir.
My lord, he will argue this matter, my lord.
420, 465. Who's for the other side? Sabyasachi Patnaik.
Sabyasachi Patnaik.
But represented by somebody was there.
Your lordship may take up Friday, my lord. In any case, he is ill.
None is appearing for opposite party number 2 today. The registry will inform Sri S. Prushti, is it?
B. Prushti.
B. Prushti, advocate, to remain present on the next day. Who has entered appearance for opposite party number 2 to remain present. This before the roster mention. On 9th May.
Item 58.
Your lordship posted to
9th May.
Obliged.
Item number 58.
Well, entry mode is there, my lord. Continue.
Very good.
Obliged.
May I please, your lordship. FIR out of the complaint case, when the alleged offense took place, the petitioner was a minor at that time, but the cognizance was taken by the SDGM court in lieu of the juvenile court.
The point is all to the trial court, sir. Permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is disposed of. Right. RFA, now you say list before the roster bench on 8th May.
Item number 59.
I may please your lordship with the
RFA is before a single judge only. Oh, anyone appearing in the RFA? No, you say none appears for the appellant. Dismissed for non-prosecution. Both RFAs. Right. Yes.
59, my lord. 59.
59 we are there.
Item 59, 58 are appearing for the opposite party.
58.
58.
Put him.
My lord, in 59, in the previous occasion, I have filed the Vaklatnama, but that has not been reflected.
You are there, sir, today.
PN Patnaik, Pragyananda Patnaik.
You are physically present today, so what's the problem?
Yes, my lord. The petitioner challenges the cognizance order passed by the Lord and SDGM by Annexure 3, my lord. This case arising out of a complaint petition, my lord. So admittedly, civil suit is there. It is a clear-cut civil dispute. And Law and Trial Court has taken cognizance by the order dated 19, I'm placing that.
Annexure 3, 1911-2015.
Yes, my lord. So, my humble and respectful submission before your lordship.
SC/ST Act also is there, sir.
My lord, I am coming to that backdrop. So, in civil dispute, admittedly, injunction is granted. Your lordship kindly have a glance. Against the opposite party, one civil suit bearing number by the Annexure 4, 221
and IA petition is also there. They have been restrained. So, my humble and respectful submission before Your Honor, there are catenary decisions. They have not 156.3. The court lacks jurisdiction to entertain the application. In view of decision rendered by Honorable Supreme Court,
You can point this all out to the court, sir.
my lord, I may respectfully submit it.
Yes, yes.
Out of Lordship, first of all, I will invite your Lordship direction, vision to visualize the situation. In case of code of, first of all, 156.3 Annexure 1 was sent, and consequently, without giving any opportunity.
At this stage, sir, there's no problem.
My lord, I am placing that.
Yes.
In case of Priyanka Srivastava and another, reported in 2015 789 SBR 12, Honorable Supreme Court clearly has, if civil in nature, resorting that provision at clock of section 3 is added mechanically. So, there are catenary decisions I have cited, and 420 is not met out in view of our own court's judgment rendered by Honorable Justice S.K. Sahu, reported in 2022 85 OCR. The ingredients is not fulfilled. So, purely civil in nature. I would like to place.
What was the transaction? Tell us, what is the transaction?
My lord, nothing is there. I would like to place the 1cc case. By Annexure 1, kindly have a glance to complaint petition, page 22, my lord. Page 24. Kindly have a glance to page 24, my lord. I am placing the relevant portion. My lord, I may permit to place the page number 24, my lord. I have to permit to place the relevant portions of the.
Please read, sir. We're not going to give, like, please continue reading.
Yes, my lord.
Whatever you want to read.
Yes. It has been averred by the complainant that the complainant possessed the said plot bearing plot number so and so, dry fence and boundary wall. Said plot need to be so and so. Matter is the accused finally gave promise to sold the said land.
So admittedly, the complainants belong to the scheduled caste, right?
My lord. But in complaint petition, he has not narrated.
No, he has said you threatened. That's there.
Yes, in view
you
of
don't have to read it all now. Page 25 is there. All those words are also mentioned.
My lord, I am in humble and respectful submission. In order to fulfill the ingredient must be fulfilled. 420 is not met out. SC Act is not met out.
Put in quotation,
admittedly,
they put in quotation. Whatever has been uttered has been put in quotations.
Yes, in view of judgment rendered by 156.3, the
you can point that
petition.
Out to the trial court, sir.
My lord, I am humbly submitting.
Yes.
To resort the provision.
Yes.
What is which has been propounded by the Honorable Supreme Court in case of Priyanka Srivastava. Priyanka Srivastava case is not followed in this case, my lord.
All right.
Yes.
Unless you place it before the trial court at the appropriate stage, how will it follow? You have to reach that stage, no? Where you will show the trial court this judgment.
My lord. My lord, my humble and respectful submission, 156.3, mechanically sent to the. Without resorting, I am placing that relevant portion before your lordship.
All right.
For your kind perusal.
All right.
in clause E, what are the provisions to be so in it is admittedly civil dispute is there, injunction order is there, my lord. Flouting that at the color, by giving a color to the criminal proceeding was initiated. That is bad in our law. That is what I am saying. And placing the placing the relevant portions which is incident and propounded by the Honorable Supreme by Priyanka Srivastav case. In Priyanka Srivastav case is not followed by the learning trial court. And that apart, there is not a whisper. Admittedly, there is a omnibus allegation that I have given money or anything, and out of that, clear-cut civil dispute is there, injunction order is against them, my lord.
All right. I am in the sub-item, my lord. My senior appearing for two brothers, my lord. I am appearing another brother who is an advocate of this court, my lord.
All right.
What happened in this case, my lord?
Yes.
Actually, my lord, the complaint was a vacant of the petitioner, my lord.
Correct.
And when it did not vacate land, my lord, and continuing there, for which the petitioners raised their objection, my lord. My lord, with the ulterior motive, without going to the police station, straightway filed the complaint case before the SDM Jajpur, my lord.
Right.
SDM sent the same to under section 150 subclause 3, my lord.
Right.
Thereafter, charge sheet submitted, cognizance taken, my lord.
Right.
Here the case, my lord, purely, my lord, though there are allegations, my lord. All the allegations are civil in nature except 3 SCST Act so far 3 SCST Act concerned, my lord. In fact, my lord, there is a civil suit pending between the parties, my lord. Right. The complaint stated in the FIR, the petitioners agreed to sell their land, my lord.
Correct. For
that reason, he filed the civil suit, and simultaneously the petitioner also filed another civil suit.
Right.
That is pending before the competent court, my lord. In fact, my lord, so far the case is concerned, before prayer, my lord, and the complaint petition that on 16/12/2013, the complaint got the certified copy of the RSD. On being asked to the accused person, they threatened to murder the complaint and disclose
read all that. Yeah.
the language there, my lord. In fact, my lord, if the petitioner come to the house of the petitioner, it is not the public place, my lord. Since it had not been taken place, so far as SCST Act concerned, had not been taken place in the public place, my lord, that cannot be but sustained 3 SCST Act, my lord. And that after, my lord, the case of 2014, my lord.
Yes.
Petitioner had to come from Kotak to Jajpur, my lord. Your lordship, my lord, taken to that part, my lord, that aspect, my lord. The period of, my lord, the certain period may give him dispose of the case, my lord. Before
that you request permitting the petitioner to raise all pleas, petitioners to raise all pleas at the approach stage before trial court. The petition is disposed of, the interim order is vacated. It will be open to the petitioners to request the trial court to expedite the proceedings. All right.
Item number 60.
On behalf of Mr. D.K. Naik, he is suffering from fever, my lord.
Tell us what the matter is about.
1 week after.
Tell us what the matter is about.
Sir, I have no brief, my lord. I have no power.
Without brief, you can't appear.
He is suffering from fever.
Sorry, sir. Without a brief, don't appear in this court.
Lord, on
without a brief, how do you appear? Without a brief, how do you appear?
Lord, only on telephone message. He is
No.
requesting me to.
No.
Only 1 week.
No, 1 minute. Let's see what the matter
is. He is fever, my lord.
1 minute, sir.
My lord.
Kindly wait for a minute.
Yes, sorry, my lord.
Who is for the vigilance department?
Vigilance.
Who is the counsel for the vigilance department? What are the instructions? Look at the order dated 12th January 2017. Are you aware?
We have filed the one FIR, my lord, but we have filed separate different charge sheets. So the court has not, they have challenged that order. That is permissible, my lord, by law.
No, you were directed to produce all the 3 charge sheets before the court. What happened?
It's not filed. That is not filed by the.
You see, by the order dated 12 January 2017, the Counsel for the Vigilance Department was asked to produce the 3 charge sheets for the court. Counsel for the Vigilance Department seeks some more time for that purpose. List on 22nd June.
Item 61.
No, please, Your Lordship. The present petition has been filed for quashing of the criminal proceeding initiated against the petitioner matter. And the petitioner and the victim married to each other, and due to their wedlock.
Correct. The affidavit of opposite party number 3 confirming that the parties have married and they have and that they're living happily is on record. That view of the matter. Put down that FIR number so and so, and all proceedings consequent that hereby quashed.
Item 62.
Nana, please.
Item number 63.
My lords, all the petitioner are 41s. So permit to withdraw my lords.
Or dismiss as withdrawn.
Item number 64.
64, my lord. Other 3 matters I was ready, but in this case, I was advised the lower court advocate to produce all the order sheet and certain documents. I require some more time.
What's the matter about? Let's see.
What are the petitioner was the owner of the vehicle, and agreement was done on the date of alleged incident, and offense was committed one of the driver. So I was not aware of the.
You can point this all out.
My lord, I been not pressed, not to file better, please. Not pressed. Not pressed.
Disposed of is not pressed.
Item 65.
May please, Your Lordship. Your Lordship, the compromise affidavit, it is annexure 5 series, page 54, my lords. This was a commercial transaction. The money has been refunded along with interest, my lords. The compromise affidavit, page 54. On that score, Your Lordship may dispose it.
But I'm appearing for the informant. I acknowledge that I have received.
I see. Counsel for the informant acknowledges having received all the payment that was due and the compromise petition that has been arrived at between the parties as a result thereof. Stop. Accordingly, bracket that according takes from the prayer clause, CT case number so and all proceedings consequent thereto hereby.
Grateful, Millers.
Item number 66.
May I please, Your Lordship? The cognizance of order is under challenge. A case is like that. Initially, a case was registered under section 272, 273 by 34 of the IPC and 47A of the Bihar and Orissa Excise Act, page 9. And subsequently, IU submitted charge sheet under section 47A of Bihar and Orissa Excise Act only, page 18. And the findings of the IO is, also kindly see page 22. Findings of the IO. Page 22, Lordship, kindly see. During course of investigation, the then IO visited the spot, examined the complainant and other witnesses, sent sample to chemical CE to SFL Bhubaneswar and obtained the same. Conducted raid, basing on the chemical report of the section 47A Odisha and Bihar Excise Act is applicable, and under section 272, 273, 34 is not applicable. And hence the accused persons are liable to 47A Odisha and Bihar Excise Act on the thereafter SI. The findings of the IO is only 47A Bihar Excise Act is applicable. Now, the page 25, Lordship, kindly see, magistrate take cognizance and all the offences where the FIR it is mentioned, my lord, without going to the record, my lord.
All right.
And examination report is also there. That chemical examination report that is not applicable to the present petitioners, and IO submitted charge sheet under section 47A Bihar and Orissa Excise Act only. And basing on the FIR, the magistrate took cognizance page 25, my lord.
All right. You say, counsel for the petitioner points out that in the charge sheet filed in GR case number 250 of 2016, it has been clearly stated by the investigating officer that basing on the chemical report, the offences under sections 272, 273, 34 IPC are not made out, and only the offence under section 47 capital A of the Orissa and Bihar Excise Act was made out. Paragraph. That will matter the impugn order dated 3rd January 2017 of the JMFC Odagaon, taking cognizance not just the offence under section 47 capital A of the B in the Excise Act, but other offences under the IPC cannot be sustained in law. To the extent that the impugn order takes cognizance of the offences under sections 272, 273, read with 34 IPC against the petitioners, it is hereby set aside. That view of the matter will continue against the petitioners in the said GR case only for the offence under section 47A of the BU and Excise Act. The petition is disposed of. The copy of the order be sent to the concerned.
Oblige.
Item 68.
The Lordship, the prayer is to quash the criminal case pending in the court of Special Judge Vigilance Sambalpur, my lord. The charges has already been filed. Your Lordship, the matter is that the accused was he was posted as Special Land Acquisition Officer for a brief period from November 2006 to 30 September 2007. And the allegation is that a false enumeration was prepared by his predecessor. His predecessor, Special Land Acquisition Officer Sambalpur, he served from 22 September 2001 to 31st/10/2006. A false enumeration report was prepared, enumeration of trees, and consequently an inflated figures were given, and the compensation was on the higher side. Your Lordship, my submission is that when enumeration was done, I was not the helm of FIR, and only 2 disbursements were paid during my tenure, and it was also ratified by the government. And the beneficiary, they signed indemnity bond, and the case was not opened up by the government also, and there is no corresponding disciplinary proceeding against me. I am leading a retired life, and therefore, therefore I have prayed for quashing of the case. And moreover, according to my information, the prime accused is dead, and 1 or 2 officials belonging to forest and revenue official, they are also dead.
No charge is going to be framed. Anyway, charge has not been framed so far.
Charge has not yet been framed.
Because this petition is pending. No stay granted here.
No, man.
But merely saying that it's pending, charge has not been framed. Maybe you can advance all these pleas at that stage, sir. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of.
Item 69.
Lord, on the given facts of the case, your Lordship will find that the continuance of criminal case will become completely abuse of process of court because it has lost its significance. Lordship would kindly see the FIR. It is lost by the excise authorities against the petitioner, saying that at the time of renewal, he filed an affidavit where he suppressed a criminal case pending against him. That was the specific allegation. Lordship would kindly turn to page 9.
Yes.
Page 9. He said the allegation here is 3 licenses of district trial court so-and-so facing trial so-and-so arising out of the GR case number 721 of 2008. That is what is allegedly suppressed in the affidavit. In fact, my Lordship, see, there is a case tagged to this matter, CRLMC 2408 of 2009. That very case is already quashed by this honorable court.
Yes.
So it has lost its significance. Even the allegation has lost its significance.
All right. What about the other 2?
No, other 2, for them, allegations are separate. So for me, it's concerned with
20 of 2017. You see the petitioner seeks the quashing of Jashpur PS case number 227 2009 corresponding to GR case number 672 of 2009 pending the court of the SDJM Jashpur. Full stop. The case against the petitioner was under section 465, 471, 198, /200 IPC on the ground that while applying for license, the fact of a pending criminal case was not disclosed. Stop. It is seen that the said criminal case was in fact quashed by this court by its order dated 30th April 2018, right? NCR LMC 2408 of 2009. That view of the matter, the very basis of the criminal case in question has disappeared. Consequently, this Jashpur PS case number 227 and corresponding to GR case number 672 of 2009, pending the court of SDGM Jashpur, and all proceedings consequent that were hereby quashed. The petition is disposed of. What about the 639 and
639 is a matter where there is an allegation that one person was caught hold of by the police or excise authorities. He was selling liquor outside somewhere at some place. They say that this person has purchased liquor from the petitioner's shop, that very person who was selling. In fact, the petitioner is the licensee. So no 47A can be alleged against the petitioner. Giving a licensee, anybody can come to my shop and purchase it. If he sells outside to anybody else, then that person will be guilty, not me. But I have prepared a very short list of dates for the Lordship. That I have said here, and you see. And that too, yes, ma'am. 47A, if Lordship sees, it's only exclusively for the person who alleges who sells liquor without a license.
All right. 639. He said the present petition seeks the quashing of PS case number 14, Badachana PS case number 14 of 2012, corresponding to GR case number 44 of 2012, pending the court of the JMFC Chandigarh, Jashpur district. Stop. Apparently, on 19 January 2012, an FIR was lodged under section 47 bracket small a for the BR and Orissa Excise Act, bracket BOE Act, bracket, by the SI of PS Chandigarh, alleging that one Nibasa Jena was selling liquor unauthorizedly at shop in village Nishimal. Stop. The statement of the Caesar witness was to the effect that the said Nibas Jena had procured the liquor sold by him unauthorizedly from one Gopal Chandra Paramanik, a licensee operating in Chandigarh. It is only one of the witnesses. The witness further added that the accused used to intermittently purchase liquor from the counter of the present petitioner, who was another licensee. Paragraph. It is only on the above basis that the petitioner, who was an authorized licensee at the relevant time, was arraigned as an accused. Full stop. Paragraph. Clearly, section 47 of the BOE Act, which makes the unlawful sale of liquor punishable, would not apply to the petitioner, since he was in fact a licensee. Full stop. Consequently, Badachana PS case number so and so, and all proceedings consequent thereto, insofar as they concern the present petitioner, are hereby quashed.
Third one is also
668.
identically placed. Here is a case lost by he was also selling liquor. But the additional point here is, for the same allegation, there was a report drawn against the petitioner. He has paid the fine. So in view of section 68, there will be no further proceeding against the petitioner. That's an additional point here. But the same thing, facts are all same. The different persons.
He has paid the fine, acknowledging the fact
So
that
compounding, in view of the compounding provision, section 75, no further proceeding will lie. It has to be, it has
That's
to.
over. You say the petitioner seems to have appeared to pay the compounding fine vis-a-vis the offence under section 47 bracket small a of the BOE Act. Consequently, no further proceedings can continue, and accordingly, Badachana PS case number 51 of 2012, corresponding to GR case number 207 of 2012, pending the court of the JMC Chandikot, stand hereby quashed. All right.
Item number 70.
None appeals dismissed. All cases.
Item 71.
May I, Lordship, please? Item 71, I am informant, my lord. It is infractious, my lord.
All right. Dismissed as interruptions.
Item number 72.
None appeals dismissed.
Item number 73.
May I please, your Lordship? FIR out of the complaint case, Lordship, family dispute between husband and wife. Matter has been amicably settled between the parties, due to which they filed the affidavit and they were called and they appeared before this honorable court.
Where is that?
The petitioner respectively submitted.
I see. You see, an affidavit has been filed by the informant stating that all the disputes have been amicably settled between the parties and that he does not wish to pursue the matter against them. That view of the matter. ICC case number 191 of 2014 and pending the court of the JMFC, Banapur, and ST case number 127 of 2016 corresponding to GR case number 223 of 2014, pending the court of the additional session judge Khurda, are hereby quashed. Copies of the order be sent to both the concerned courts.
Obliged.
Item 74.
None appeals dismissed.
Item number 75.
None appeals dismissed.
Item number 76.
None appeals dismissed.
77.
Yes, ma'am. This is case, my lord. Annexure 3, page 48, a proceeding, criminal proceeding was instituted against me on the basis of the report of the state level scrutiny committee. That is Annexure 1, your lordship. Annexure 1, my lord, the affair, page 9, and the relevant page is, my lord, 11, the final report is the FIR. Final report is the FIR. And that has been challenged before this honorable court. And this honorable court has quashed the final report and remanded it back to the committee for de novo inquiry. Still, the criminal case is pending. Quashing is the Annexure 2, your lordship. Annexure 2, the final report was quashed
by the order dated
Annexure 2, page
2nd August 2011.
Right.
Passed in WPC 14765.
Achha, by the order dated, judgment dated 2nd May 2011. Sorry, 2nd August 2011. In WPC 14765 2009.
My writ is Annexure 2, your lordship. My writ is 7811 2009. That is a covered judgment. My case is WPC 7811 by 2009.
Annexure C that by the order dated. All right. Order dated 10th January 2012. In WP Civil 7811 of 2009. The writ petition was disposed of in terms of a judgment dated 2nd August 2011 in WP Civil 14765 2009. Whereby the committee of the report of the committee, state level scrutiny committee, insofar as it pertained to the present petitioner, has been quashed. Consequently, the criminal case instituted on the basis of the said committee report also cannot survive,
My lord, there was a direction for de novo inquiry. If in the de novo inquiry is found to be guilty,
Right,
then
right, obviously, sir, obviously. But consequently, take from the prayer clause and all proceedings consequent thereto hereby quashed. Paragraph, it is clarified that if in any de novo inquiry by the state level scrutiny committee, facts emerge, then the present order will not prevent the institution of any fresh case.
Yes.
Against the petitioner. Right.
Item 78.
In item 78, my learned senior, Mr. Rajadevandas was the conducting counsel. Since he is in the government panel, my lord, petitioner wants to engage another counsel, my lord.
It's all right. What's the matter about?
So, my lord, I pray only 1 week, my lord.
No, no. What is the matter about? 2BCC case number. Cognizance order.
illegal mining.
Ah. All right. Counsel for the petitioner's state should be now in the government panel. And the petitioners seek to make alternative arrangements. This before the roster bench on 8th May, interim order cut.
Item 79.
May it please your lordship. In item 79, I am there for the.
And I am appearing for the complainant, my lord.
Here is the case of quashing of criminal proceeding, but where initially one FIR was lodged and one police submitted the final report. Your lordship will find it at Annexer 2. Sorry, my lord, Annexer 3, my lord.
Yes.
May I read it, my lord?
Yes, yes.
During the course of investigation, I visited the spot, examined the complaint, and
this must be a protest petition on that, sir.
Sorry, my lord.
This must be a protest petition on that.
No, my lord, no.
Where is the order accepting this final report?
At the same time, my lord, the complainant filed one CC case, my lord.
So that's like a protest only, sir. It's the same case. It's not a separate case.
No, in the same case.
My lord, in the complaint petition also, the mention on the FIR was
correct.
The cognizance was taken without the mandate for provision of 197. No sanction was taken, my lord.
That finding was given, my lord. May kindly have a glance at page number 33, my lord. Page 11 of the internal part of the order. The fourth line, my lord. Who has been the accused here, my lord, who has been cited as the accused was in civil dress, and it further transfers that he was not performing any official.
That is a matter of evidence before the trial court.
Yes, my lord. That
permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. Right.
Oh, please.
Item number 80.
My lords, I am from the informant, my lords.
May I please, your lordship? FIR out of the complaint case. Complainant is the mother-in-law of the petitioner number 1. And petitioner number 2 and 3 are her brother and sister-in-law. Alleged offences are under section 323, 294, 354.
There's no compromise between the parties.
My lords.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Lords, my appearance may be noticed.
Okay.